be a part of everything. Ah,
Okay, it looks like you're going. You guys can go ahead and start your trial at this point in time. Thank you very much. Good luck.
great. And we're still minus a witness, but we're going to go through introductions. If lead counsel for the prosecution would introduce him or herself.
Hello, Your Honor, members of the jury, opposing counsel. My name is Eleanor Hunt, and I will be directing Jordan Markowitz and crossing Avery Becker today.
And next attorney in line for the prosecution.
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Lily Kim, and I will be performing the opening statement on behalf of the prosecution, the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Thank you. And final attorney for prosecution.
Good afternoon, Your Honor. My name is Abby Amen. I will be performing the direct exam of Kyle Kuzak, the cross-exam of Professor Van Owen, as well as closing arguments.
And long A on your name, Amen.
Yes, Your Honor.
Thank you very much. And if we could have let me see, Mr. Filerman is a witness for which side?
The prosecution, Your Honor.
Prosecution. Let's go through, let's give him as much time as we can. Let's have counsel for the defense team first, with lead counsel first.
Good afternoon, Your Honor, and members of the jury. My name is Grace Murphy, and my co-counsel and I represent the defendant, Avery Becker, in today's case. Permission for my co-counsel to introduce themselves?
Yes.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Lola Fakes.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Tess Hayden.
Permission for our witnesses to introduce themselves?
Hang on just a moment. And that's Ms. Hayden, is third chair. And if we could do, whoops, hold on here. I can't do two things at once, sorry. Can't multitask. There we go. If we could have defense witnesses first, again, we'll give Mr. Filerman a little more time. So first witness up for the defense, if you could give your actual name and then your character name, please. For the defense. Do we have a defense witness?
My apologies, Your Honor.
That's okay.
My name is Lily Humber, and today I am Professor Blake Van Owen.
Good afternoon. My name is Saffron Bennett Spurlock, and I'm Avery Becker.
Good afternoon, Your Honor.
Hang on just a moment. Last name is hyphenated here. I'm only getting part of it. It is Ms. Bennett
Spurlock, Your Honor.
I'm sorry, I talked right over you. My fault. Go right ahead.
No, go ahead. I was just saying it's Bennett Spurlock.
Spurlock, thank you. And last witness.
Good afternoon, Your Honor. My name is Alexander May, and I am Taylor Perkins.
There we go. Ms. May, okay. And do we have the first witness for the prosecution?
Yes, Your Honor. Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Lauren Krause, and I am Alex Cifuentes.
And the next witness.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Tate Ham, and I am Detective Jordan Markowitz.
And then we will have Mr. Spurlock. I'm sorry, Mr. Spurlock, Mr. Filerman. And I should remember the character's name, but I don't.
He is Kyle Kuzak today, Your Honor.
Kuzak, okay. I think what we'll do is just go forward and give him as much time. Is he going to be your last witness on the prosecution?
Yes, Your Honor.
Okay, we'll give him as much time as he needs to get on the line. He may be having technical difficulties. And just before we begin, everyone, of course, knows this is a new age, a new way to do this. we're going to run into these problems. I don't consider it'll be a problem, that you will be able to get a hold of him. Remember that if he cannot connect directly by through his computer, his laptop, or his internet connection on his phone, he can always cell phone in. He can telephone in, and I think that you have the knowledge on how to do that, probably better than I do. It was just explained to me, and I think I could do it if I had to, but you're probably much more capable. Just tell him if he needs to do it that way, we're happy to take his testimony by phone without video. So with that said, let me get into the rules and some other matters. The first
Briefly,
is—
Your Honor, before
yeah.
trial begins, would you like us to provide our roster within the chat for your viewing?
You may do that. It is absolutely, you may do that. Given the electronic scoring sheets that we have, I'm going to be instructing you in just a moment that before each section, each witness, whether it's opening, closing, or a witness, I will ask each attorney and each witness to identify themselves. So your names are on the screen. You'll be saying your names. It's really not a problem for us not to have those sheets in front of us. So don't worry about it.
Okay, thank you.
You bet. First issue, of course, is whether or not the prosecution is ready for trial. Lead counsel, Ms. Hunt.
Yes, Your Honor, the prosecution is ready.
And lead counsel for the defendant, Ms. Murphy, is the defense ready?
Yes, Your Honor.
We've just addressed the issue of the team roster, and I will not repeat that. I need to remind all of the participants and all of the coaches, parents, friends who are watching us on YouTube, please do not record this. It is not although it is public to the people who are invited, it is not a public matter and cannot be recorded without permission. Excuse me. The Bar Association, of course, by your participation, has the ability and the permission to take screenshots of you and publish those if they so wish. No recesses will be allowed, as you are aware, unless there is a health emergency. Please do not be shy if there is a health emergency to indicate as such, and we will take a recess to resolve any issue. Also, because of the virtual format here, if we have a connection problem, and we had one in our trial this morning, and it was handled very smoothly. We did have the witness recall by phone, so we had audio testimony rather than video. Turned out to be just a connection problem. She later moved closer to her router and we got her back. But if there is a problem, I will instruct the timekeepers not to charge that time. If we have intermittent interruptions, I may very well, I keep track of that usually by 5-second increments, and I may add time to an examination if that happens. So don't be concerned if that should happen. You will get the full time you need to do your examinations. Let's see, I'm just going through these things. Some of them don't apply anymore because it's virtual. I'll remind both the applicant or the participants here, the attorneys and the coaches who are on YouTube, that if there are disputes that arise, whether they are within the trial or outside of the trial, those must be addressed appropriately under the rules. I'm going to swear you all now in 4 groups, including the timekeepers. And I will, if we do not have Mr. Filerman online, I will not only swear him in as a witness, but I will swear him in as a participant at some point, depending on when he joins us. But first, I would ask all of the attorney members, please, to raise your right hands. And do you, as team members and attorneys, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And you may nod or say yes if your mics are on.
I do, Your Honor.
I do.
And now all of the witnesses that we have, the 5 of 6, if you would raise your hands. As witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
I do.
I do.
And finally, well, not finally, but next, the scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
I do.
Thank you. And finally, our timekeepers, if you would raise your hands, do you promise to faithfully keep the time as requested by the attorneys and according to the rules in the competition?
I do.
Good. Okay. Next, one of the, these are just preliminary rules again. As to timekeeping, on the prosecution side, do you have any specific requests for the timekeeper or timekeepers as to how you would like to be notified of remaining time, both in closing and opening, or opening and closing, and as a separate matter during witness examination? And I would ask lead counsel for the prosecution first.
Sorry, I'm having some trouble hearing you. Do you think you could repeat that question, Your Honor?
You bet. If you have any specific instructions for the timekeepers as far as keeping time during opening and closing, and also keeping time during witness examination, how you would like to be informed in what increments?
I think what's worked best in previous rounds is just in the chat. If our timekeeper can say 20, 10, or increments of 5 minutes, that's been pretty helpful. And then in like the last minute, we can do it by seconds.
Okay. And Ms. Murphy, for the defense, do you have any instructions?
No, Your Honor.
All right. And is that all acceptable to the timekeepers?
Yes, Your Honor.
Yes, Your Honor.
Thank you very much. All right, as far as exhibits are concerned, if you wish to post exhibits during the introduction process in order to qualify an exhibit, to admit an exhibit, you may post those on the screen, even though the jury will be able to see those even before they're admitted, because the jury is not deciding this case on the evidence, but on presentation. Doesn't make any difference if they see it. If I don't admit the exhibit, once we all see it, I will simply instruct the jury to disregard it. So are you prepared on the prosecution side to have co-counsel screen share to produce an exhibit?
Yes, Your Honor.
And on the defense side, Ms. Murphy?
Yes, Your Honor.
Great. And once, if I admit it, I will instruct you that you may publish, and then all you need to do is instruct the co-counsel to publish it. It may already be on the screen, so they don't have to do anything, just the distinction between admitting the exhibit and then publishing it. During your examination, of any witness, I would ask that counsel asking questions, whether it's direct or cross, and opposing counsel have their video activated at all times and their microphone open, so that you don't have to fumble around trying to open a microphone to make an objection. We've not had any problems with background noise in any of the trials, and I'm certain that there won't be any here. So leave your mics open, leave your videos on, so that during any examination, I will see 3 screens, witness, and both prosecution and defense attorney. Also, during your examination or during opening and closing, Please feel free. If you wish to stand, you may, but you may also do examination or argument or statements seated. You will not be graded either way, up or down, whether you stand or sit. It is perfectly acceptable in this day and age in virtual hearings and trials that counsel may work seated. That's up to you. Otherwise, before we get to opening statements, are there any issues on the prosecution side, Ms. Hunt, that you would like to address with the court?
Your Honor, we ask that any time remaining after closing statements be saved for rebuttal.
And we will do that for both sides, yes.
And I think, oh, we also ask that should any technological issues like cutting out, we ask that our time on direct examination be paused.
If it's a longer period of time, the timekeepers will take care of that. Certainly, if it's a very short period of time, I'll keep track of it. And like I say, I usually do it in 5-second increments. Timekeepers probably won't do that. So but I may just add, 20, 30 seconds or something if there are a bunch of very short interruptions, having to repeat questions, things like that. So yes, I will take care of that. Thank you.
Thank you, Your Honor.
Anything else for the prosecution?
We ask that those two motions be extended to opposing counsel as well.
Absolutely.
Thank you. No further motions.
And Ms. Murphy, anything for the defense you'd like to talk about?
Yes, Your Honor. We have one at this time. We ask that the stipulated facts agreed to before trial today be constructively read into the record.
And assume that they are, yes.
Thank you.
Anything else? Anything else on the defense side?
No, Your Honor.
Thank you. Okay. We will now proceed, and just to confirm, is the scoring jury all ready? Mr. Prey?
Yes, I'm ready, sir.
And Magistrate Ryan?
Yes, Your Honor.
And Mr. Henderson?
Ready, Your Honor.
Good enough. We will now begin with opening statement from the prosecution. Ms. Kim, I believe.
Yes, Your Honor. Your Honor, ladies and gentlemen of the jury, Avery Becker was ousted, outraged, and out of control. You will hear today that Avery was on an undeniable quest for revenge, and on March 6th, 2020, she took her actions too far. She broke into her mock trial coach, Mr. Brackman's home with the intent to vandalize it, just as she vandalized his car before. And when she was surprised to find him at home, she used his own self-defense weapon to kill him. As you will hear from several witnesses today, including Avery herself, Avery had a special talent when it came to mock trial. She was an award-winning actor playing the role of a lawyer, an outstanding witness, and had the ability to seem completely believable on the stand, the same place where she will sit and speak to you today. Avery's history of acting out proves that she simply could not handle missing out on mock trial. She has lost her self-control, not once, not twice, but 3 times. The first time, Avery's disrespectful behavior got her ousted from the A-team, the place where she was the center of attention. So she encouraged her best friend Taylor to quit the team for her, and Taylor did. The second time, Mr. Brackman gave Avery constructive criticism about her mock trial awards, but Avery became outraged and out of control. She took a permanent marker, she walked out of practice, and she vandalized Mr. Brackman's car. When Avery got home, she was still outraged. She even told her mom she was going to get back at Mr. Brackman. Avery has a temper. Does it sound like she makes rational decisions when she's outraged? That brings us to the murder of Mr. Brackman. So the third and last time when Avery was ousted for good, she was overcome with anger and desperate for revenge. She was out of control and nobody could stop her from her plan. So first today, you will hear from Alex Fuentes, who will tell you about that plan of Avery's to break into Mr. Brackman's home and show you the text messages that prove it. Then you will hear from Detective Markowitz, who will show you a diagram based off of Avery's cell phone data, the data that proves Avery was near Mr. Brackman's house at the time of the murder. She will show you ring video footage of the intruder, of the same height and build as Avery Becker. Then you will hear from Mr. Cusack, a crime scene reconstruction investigator for the city of Denver, who concluded that this was a planned burglary gone wrong. Then you will hear from the defense's witnesses. While you listen to Avery, I ask you to listen to her tell you that she was the best on her team, that she won awards, but also that she was angry at Mr. Brackman. Today, Avery will claim she had an alibi. And who will give us Avery's alibi? Taylor Perkins, Avery's very best friend, Taylor, Avery's most loyal friend, Taylor. Not only a conflict of interest, but the alibi doesn't even make sense. You will hear from the defense's expert, Miss Van Owen, a paid witness who criticizes the prosecution's investigation, but only conducted a partial survey of the evidence herself, on which she bases all of her conclusions. At the end of this trial, we, the prosecution, will ask you to declare Avery Becker guilty of felony murder and second-degree burglary. Ladies and gentlemen, keep in mind that we do not have to prove to you that Avery planned to murder Mr. Brackman. We only have to prove that during a second-degree burglary, she killed him. We must prove this to you beyond a reasonable doubt, and the evidence will show you today that Avery had the motive and intent to trash Mr. Brackman's house, and while she was out of control doing it, she killed him. Avery will tell you today that none of it is true. She will do everything in her power today to try and reverse the consequences of what she did when she was ousted, outraged, and out of control. Thank you.
Thank you. After each concluded section, whether it's a witness opening or closing, my practice is to pause for a moment so that the timekeeper or the scorekeepers can complete any evaluation of that particular presentation. It only takes a few seconds. I won't repeat this, but during the time that I've said it, we'll now continue to opening statement for the defendant. And it's pronounced Fakes, is that correct?
Yes, that is correct.
Thank you. And Ms. Fakes, opening statement for the defendant.
May I proceed, Your Honor?
Yes, you may.
No phones, no files, no felony. Your Honor, members of the jury, my name is Lola Fakes, and my co-counsel and I are here today to represent Avery Becker. Ms. Becker stands here today falsely accused of second-degree burglary of a dwelling and murder of the first degree. The prosecution accused Avery Becker of the murder of her mock trial coach, Mr. Mackenzie Brackman, before their investigation began. They looked into no other leads or suspects, and the incomplete evidence they will present today will clearly reflect that. The case the prosecution will offer is simply put, unfinished. The prosecution will call 3 witnesses to the stand. You will hear from Alex Cifuentes. Alex, the prosecution's only character witness, is a fellow mock trial student, jealous of Avery's recognition on the mock trial team. You will hear that Alex was the last person to see and use Avery's phone on March 5th, the night before the murder. The same night, Avery's phone went missing. Alex claims to have a text conversation with Avery about planning to go to Mr. Brackman's house. You will also hear from Detective Jordan Markowitz, who will explain that she accepted these screenshots of this purported text exchange directly from Alex, with no attempts to verify their authenticity. None. You'll hear that the cell tower data collected by Detective Markowitz on Avery's phone the day of the murder cannot tell us where Avery's phone was that day, as phones do not always connect to the tower closest to them. Van Owen, a crime scene investigator on the defense, will explain that phones commonly connect to cell towers up to 7 miles away from the phone's location, meaning a phone in downtown Denver could connect to a tower in Stapleton. While the phone data may give us a picture of the phone's location, it still can tell us nothing of the location of Avery on the day of Mr. Brackman's murder. You will hear that Detective Markowitz has failed to locate Avery's phone. Detective Markowitz has failed to reach Alex's phone to authenticate the supposed text messages. The detective has also failed to reach the one phone that could confirm or deny their lead suspect's alibi, Taylor Perkins' phone, as Taylor was with Avery on the day of the murder. Where is Avery's phone? Where is Alex's phone? And where is Taylor's phone? All untouched by the police and not in court today. Kyle Kuzak will also be called to the stand. Kuzak, a civilian worker on the police force, will try to reconstruct the scene for the court, but will fail to do so properly. Kuzak visited the scene after it was processed by Detective Markowitz, using only the evidence from Detective Markowitz, following Markowitz's leads. Additionally, the police allowed important picture evidence to be corrupted, making it unavailable to the court today. This is just another example of the incomplete evidence on the detective work on this case. The defense will bring to the stand Van Owen, a crime scene investigator. Ms. Van Owen will help highlight the failings of the investigation. She will explain the ridiculous reconstruction of the scene, of scuff marks that cannot be dated, of ring notifications that were never checked, and the impossibility of a teenager of Avery's stature to reach the knife wound found on a grown man's shoulder. You will also hear from the defendant herself, Avery Becker. Avery will clearly explain to you that she did not commit this crime, and that she, a teenager with a loose connection to Mr. Brackman, is not the criminal they are looking for. Lastly, you will hear from Taylor Perkins, Avery's alibi, who will fully corroborate the whereabouts of Avery on the day of Mr. Brackman's murder, making it ever more clear that Avery had nothing to do with this crime. Ladies and gentlemen of the jury, Mackenzie Brackman was a criminal defense attorney, a job that will naturally provide you with enemies. Yet Detective Markowitz will fail to acknowledge any other suspects in the case. Taylor Perkins will bring your attention to Blair Rollins, a fellow mock trial student on the team, whose father was put in jail, and who was his lawyer? Mackenzie Brackman. You will hear that Blair Rollins was not at school the day of the murder. You will hear that Blair Rollins has recently seemed to have disappeared. You will not hear of any investigation on Blair Rollins by the prosecution. No phones, no files, no felony. The investigation on Mackenzie Brackman's murder is lazy. The prosecution found only the evidence that supported their claims and ignored to look into any other leads, theories, or pieces of evidence that would contradict their choice of suspect, Avery Becker. I will remind you, the prosecution holds the entire burden of proof in this case. I ask the jury to keep in mind the prosecution must prove their case beyond a reasonable doubt. It is your job to ask yourself through every moment of testimony today if there is any reasonable doubt. I ask that you remember what the prosecution is missing from their case. No phones, no files, no felony, and find my client, Avery Becker, not guilty. Thank you, Your Honor.
Thank you. As I indicated, I will pause. What I'm going to do, I see Mr. Filerman is with us. I'm going to swear him in as not as a witness, but the oath for the competition. And Mr. Filerman, if you could activate your video there. Great. And please raise your right hand. As a witness, do you promise that the testimony you're about to give later in the case will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Thank you very much. Okay, we'll now proceed with the trial and have the first witness for the prosecution. If I could have the attorney on direct, please.
Yes, Your Honor. The prosecution would like to call Alex Fuentes to the stand.
And do I have, there we have defense counsel as well, Ms. Kim for the prosecution, Ms. Fakes for the defense, and I will assume that we have a witness in the stand. I'm going to ask you before I swear you in for your character name and your student name, please.
My character name is Alex Cifuentes, and my student name is Lauren Krause.
Okay, and please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ms. Kim, you may proceed.
Thank you, Your Honor. Could you please introduce yourself to the jury?
My name is Alex Cifuentes, Sifuentes.
Tell us a little bit about yourself.
I'm a senior at Colorado High School, and I'm on the mock trial team.
Could you please tell us a little bit about your relationship with Avery Becker?
We were on the same mock trial team and we were good friends.
How did you end up on the mock trial team?
Avery actually introduced me to the team.
Let's talk about mock trial. What is mock trial?
Mock trial is a club that simulates a real-life court case with witness and lawyer roles.
And how would you describe Avery's role on your mock trial team?
Avery was a very talented lawyer and witness because she could always make up anything on the spot and be believable.
How did you know Mackenzie Brackman?
He was our coach for the mock trial team. I really loved and respected Coach Brackman.
And how would you describe Mr. Brackman as a person?
He was a great coach and lawyer because he valued hard work and he always wanted the best for the team.
Based on your perceptions, how would you describe the relationship between Avery and Mr. Brackman?
From what I could tell, Avery always disliked Coach because he tried to push her to prepare more and be on time, but she never did.
Objection, Your Honor, speculation.
Ms. Kim?
This is rationally based on the witness's perception of Avery and Mr. Brackman in mock trial practice, as she was present multiple times throughout practice throughout the past 4 years of high school.
Ms. Fakes?
Your Honor, this witness cannot testify to the inner feelings and desires of Avery Becker.
I'm going to overrule the objection. The question merely asked for an observation from Ms. Cifuentes as to what she observed. The answer was she was late. That is an observation. Objection overruled. Ms. Kim, you may proceed.
Thank you, Your Honor. What did Mr. Brackman do about that?
He demoted Avery to the B team.
Could you tell us what that was like?
It was very tense. And then Avery's other best friend, Taylor Perkins, also quit, which then forced Coach to let Avery back on the A team.
From your perceptions, how would you say the team reacted to this?
Everyone was very upset about Avery being let back on the A team, and then even more upset about her awards.
What awards?
She won Best Attorney and Best Closing Argument at the regional tournament.
Could you tell us why those awards were significant?
Well, Coach tried to explain to her that she shouldn't take them as good lawyering because she needed to learn how to work hard and properly prepare.
Objection, Your Honor. Hearsay.
And Ms. Kim?
Under Rule 801D2, Mackenzie Brackman is an unavailable declarant in this case, as he is deceased.
Ms. Fakes?
Your Honor, this is still hearsay. It is still a statement outside of court being used to prove the truth of the matter asserted.
All right. I'm going to overrule the objection. It is an out-of-court statement. There may be an issue as to the availability of the declarant, the decedent, but at the foundation, this is not being offered for its truth, not being offered for the truth of whether or not the statement is true, merely that it occurred and what the effect on the listener and other people was. So not hearsay. Objection overruled. You may continue, Ms. Kim.
Thank you, Your Honor. Could you tell us why those awards were significant?
Well, with Coach trying to tell her that she shouldn't take them as good lawyering, she just got angry and was so out of control.
You say she was out of control. What did she do?
Well, she looked outraged when leaving practice. She vandalized Coach's Porsche by writing Worst Attorney Award in permanent marker.
Objection, Your Honor. Improper character evidence.
And which part of the evidence is, which part of the testimony is character evidence that you're objecting?
Yes, Your Honor. I believe the part of the testimony that she became outraged and wrote on a car. I believe that this is being used to prove that she also acted in accordance on the day of the murder, seemingly being outraged.
May I respond?
Yes, you may.
She did not say that she was outraged. She said that she looked outraged. She was describing Avery's appearance, Avery's reaction, and what Avery did at practice that day, which is most certainly relevant to this case in respect to her state of mind with respect to Mackenzie Brackman in this case.
Ms. Fakes?
Your Honor, this is still being used to prove the character trait of being outraged and vandalizing a car. That was that's being used to prove that this happened on other occasions.
I'm going to allow you, Ms. Kim, to re-ask the question as to what Ms. Cifuentes observed. If she observed characteristics of outrage, she may testify to that.
Thank you, Your Honor.
Yes. Thank you, Your Honor. What did you observe about what happened at practice that day?
Well, after talking to Coach, Avery stormed out of practice and grabbed a permanent marker and wrote "Worst Attorney Award" on Coach's Porsche.
Were you at practice when that happened?
Yes, I saw her leave and grabbed that Sharpie from our paper easel.
Are you sure it was a Sharpie?
We had both Sharpies and dry erase markers in the room, and they're easy to tell apart.
What did Mr. Brackman end up doing about his car?
He didn't even press charges against
Objection outside of the scope of the witness's knowledge.
If you can lay a foundation, Ms. Kim, Ms. Fuentes can testify to it.
Did you ever hear, or did Mr. Brackman ever say what he did about his car? Did you notice if Avery got in trouble?
Your Honor, objection calls for hearsay.
And Ms. Kim?
May I rephrase my question?
Yes, you may.
What did you notice that happened after this incident?
Well, Brackman didn't even press charges against Avery, but he did demote or kick her off the team for good.
What happened after this incident?
Avery texted me and asked me if I would talk to Mr. Brackman about letting her back on the A team, so I begged him.
Objection, Your Honor. Best evidence. These texts we asked be offered for the jury.
May I respond?
Yes, you may.
I'm providing a little bit of foundation as to the chronology of events that led to these text messages, and I will be asking about these text messages later, but I'd like to provide some foundation first.
I'll permit the latitude to lay the foundation. Go ahead.
Could you please would you like me to re-ask the question?
Yes, please.
Could you tell us what happened after this incident?
Well, Avery texted me and asked me if I would talk to Coach about letting her back on the A team, so I begged him to.
Why did you do this for her?
We were between regionals and state, and even though I honestly would have gotten a bigger role, I wanted the best for the team, and I wasn't going to let my personal interests get in the way of our team's success.
How did Mr. Brackman end up responding to your question?
Unfortunately, he wouldn't let her back on, so I texted Avery back and told her what he said.
Your Honor, may I have permission to ask this witness to pull up a copy of Exhibit 14?
Yes.
Could you please pull up a copy of Exhibit 14?
Yes.
Do you recognize this image?
Yes, this is a screenshot of Avery and my text messages after I told her she wasn't going to be allowed back on the team.
When did this text exchange occur?
The night before the incident and right before I saw Avery at the Fry Shack.
What did you do about these messages once you were approached about this trial?
Well, after the horrific incident, I got a call from the detective and I told her about the text messages and sent the exact screenshots of the messages to the detective after my interview.
Are these an exact copy of those screenshots?
Yes.
Your Honor, I would now like to offer Exhibit 14 into evidence.
And Ms. Fakes, any objection to 14?
Yes, Your Honor. I object under Rule 1003, admissibility of duplicates. This duplicate is admissible, this screenshot, to the same extent as the original, unless a genuine question is raised about the original's authenticity, and the circumstances have made it unfair to admit as the original has not been authenticated.
May I respond?
Ms. Kim, yes, you may.
The defense's response addresses the evidentiary weight of these text messages and not the admissibility. It is up to the jury to determine their authenticity.
And Ms. Fakes?
Your Honor, to admit these documents, these screenshots would show some level of authenticity, which has not been proven or foundation has not been laid for.
All right, I'm going to admit 14 over objection because Ms. Cifuentes has indicated that these are the ones that she is aware of. I know that there is a dispute here as to whether or not these are the same messages that were transmitted as were given to the police. That is an issue of credibility of the witnesses as to whether or not it was changed. But this witness has identified these, and I will admit them for this witness. I anticipate that other witnesses may testify to other issues, but not to the admission of the evidence, but to the credibility of who created the credibility of the people who created them and who allegedly may have changed them, although that is will be saved for another witness. So 14 comes in. Ms. Kim, you may proceed.
Thank you, Your Honor. May I have permission from my co-counsel to screen share a clean and unmarked copy of Exhibit 14?
Yes. And screen sharing is tantamount to publishing. They are now published.
Could you please read the third to last gray bubble on the second page, please?
Well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
Is this what Avery said to you?
Yes.
How did you respond?
I asked what she was going to do to Mr. Brackman's house.
What did Avery say after that?
She said, I'm going to wait until he's at work, then break in and trash it.
Did you tell anyone that she said this?
Not immediately. I mean, I'm her friend. I gave her the benefit of the doubt that she wouldn't make another mistake after Coach's car. So I just told Avery that it wasn't a good idea.
I'd now like to talk a little bit about your last interaction with Avery before this trial. How would you describe that interaction?
I saw her at the Fry Shack the evening before the murder, and we had a great talk about mock trial and the team, and she thanked me for talking to Coach, and then she even let me play a game on her phone.
Who else was with you at the Fry Shack?
Taylor Perkins was there as well.
Do you recall someone named Blair Rollins being with you at the Fry Shack?
No.
Objection, lack of foundation, Your Honor.
Well, that was the question. Did she know? And she said no. So did she see him? She said no. That's the foundation question. Let's proceed.
Could you tell us who Blair Rollins is?
I went to school with Rollins, but I don't even know if we had a class together. I mean, I barely knew who they were.
Did Blair participate in mock trial?
No.
Okay, now I just have a few more questions for you. We've talked a lot about Avery's role as a lawyer on your mock trial team. Was she always a lawyer?
She was a witness several times, too.
Did you see her as a witness?
Yes, I did.
Did you see her as a lawyer?
Yes.
How did you view Avery's overall skill level in mock trial, given that you've seen her as a lawyer and a witness?
She was really talented. She was a good lawyer, and as a witness, she came off totally sincere and believable because she had this amazing ability to make things up on the spot and convince you that they were completely true.
Thank you, Alex. No further questions, Your Honor.
We'll pause for just a moment before cross-exam. And Ms. Fakes, you may now cross-examine the witness.
Thank you, Your Honor. Good afternoon, Ms. Cifuentes. I'd first like to draw your attention to the day Detective Markowitz brought you in to interview. Is it true that on the phone you spoke with the detective about the text messages that you received from Avery?
I did.
And you went into the station to interview about this?
Yes.
So after your phone call about the text messages, you went into the station to interview about the text messages?
Correct.
And on your way...
And I'm sorry, is there an objection?
Yes, Your Honor, this question was just asked and answered.
And it was asked and answered on direct. It is now being asked and may be answered on cross. Go right ahead.
Thank you, Your Honor. Now, on the way to the station about this interview, about these text messages, you forgot your phone, didn't you?
I mean, I knew in order to show the text messages, I had to have my phone charged because it was really old, so I completely forgot it.
So you forgot your phone where you needed to have your phone?
My dad was yelling at me. I was full of nerves. I mean, talking to an investigator, but I just simply forgot it. It's totally my fault.
Sure. Now, the detective said that the screenshots of text from you were okay.
Yes, they were the real messages.
And the detective accepted these screenshots from you?
Correct, because they were the real messages.
The detective didn't ever try to physically retrieve your phone?
There was no need because these messages were sufficient considering they were the real ones.
So no, the detective did not try to physically retrieve your phone?
There was no need, no.
And to your knowledge, the detective didn't try to verify the text further?
We had what we needed and they were sufficient, so no.
Now this phone is no longer in your possession, is it?
My phone only got worse with time and eventually I did have to get a new one.
This phone is not here in court today?
I have a new phone now, so no, I no longer have that phone.
Now, you didn't provide the detective with the text messages until a day after your meeting with the detective?
Well, I hadn't known that I would forget my phone, so I provided them when I needed to.
A day after?
Correct.
So that means you had an entire day to possibly forge this purported text exchange?
Well, we had already talked about having the messages, so I don't see why I would forward it before I would agree to an interview where I would willingly show the text messages.
Thank you, Ms. Fuentes. Now, I'd like to bring your attention to the text messages. Do you need them put up on the screen?
That would be helpful, please.
May my co-counsel show Exhibit 14, please?
Exhibit 14, yes.
So I'd like to bring your attention to the first text from Avery where Avery supposedly says, "Hey, Alex, it's Avery."
Okay.
Now, you've been on the mock trial team with Avery for 3 years, haven't you?
I have.
And you claim that Avery is your friend.
Yes, we're good friends.
You've claimed that Avery is your best friend.
Correct.
And yet in these screenshots, she begins her first text with introducing who she is.
Sometimes you should introduce yourself just so people know where that's coming from.
Sure. And to the best of your memory, there is no timestamps on these texts, is there?
Not in this screenshot, no.
No. Thank you, co-counsel. Missy Fuentes, you know Blair Rollins, don't you?
I know of them. I know of a lot of people that go to Colorado High School.
Right. They went to school with you?
Yeah, I don't even know if we had a class together, but they did.
And you talked in your affidavit about Mr. Balkin representing a Colorado high school student in trial before?
Yes, everyone at CHS knows about that.
Objection. Under Rule 401 and 402, how is this relevant?
Relevance objection, Ms. Fakes. Are you going somewhere with this?
Yes, I am, Your Honor.
Okay, I'll give you a little latitude. Let's get there.
Thank you. Missy Fuentes, did Detective Markowitz ever ask you about Blair Rollins?
No, because I barely know Rollins.
Detective Markowitz never asked you about any other suspect, did they?
There was no need. What I had was directly for Avery.
She never asked you about any other person besides Avery Becker?
There was no need to. I didn't know of anything else besides what I had in the text messages.
Moving on, Missy Fuentes, you spoke in your direct about how Avery has amazing ability at mock trial, doesn't she?
She's great at improvising, yeah.
Yeah, she could go off script.
Yeah, that's what improvising is.
She would make things up on the spot.
That was how she rolled.
And she won awards for her performance?
She won awards for what the judges saw, and that was her improvisation, but not her preparation at all.
Right, well, you working for hours and hours on a line of questioning or memorizing a rule have nothing to show for it, do you?
Well, I do spend a lot of time at mock trial, but Avery came off and improvisation worked for her, but improvisation can easily go the other way. So it was luck.
Sure. Now, Mr. Fuentes, lastly, I'd like to talk about the night you saw Avery at the Fry Shack after she got kicked off the team. You played a game on Avery's phone, didn't you?
We were having such a great conversation that she obviously felt comfortable enough giving me her phone to play a game.
So you had her phone in your possession?
With her permission, yes.
So you had access to her phone the night before the murder of your coach?
And she knew I had it because I was playing a game on it.
And are you aware this phone is now missing?
That's what Avery says. I don't really know much about it.
You are aware that the phone was last seen in your hands?
That's what Avery claims, but really I just played a game on it and gave it back to her.
Thank you. No further questions, Your Honor.
We'll pause just a minute before redirect, or just a second or two before redirect. And Ms. Kim, you may redirect your witness.
I have no redirect, Your Honor.
With no redirect, there is no recross. Ms. Cifuentes, thank you very much. You're excused. We'll pause just a moment so the scoring jurors can catch up with the current performance before we have the prosecution's second witness. And if we could now have counsel for the prosecution and enter an appearance and call a witness to the stand.
Yes, Your Honor. The prosecution would like to call Detective Jordan Markowitz to the stand.
And Ms. Hunt for the prosecution. We have Ms. Hayden for the defense. I have a witness on the stand, Ms. Markowitz. And I'm sorry, Detective Markowitz, I apologize. And ma'am, if you could give your character name and your student name, please.
Yes, my name is Detective Jordan Markowitz, and my name is Tate Ham.
And Detective Markowitz, if you could raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. And Ms. Hunt, you may proceed with your witness.
Thank you, Your Honor. Hello. What is it you do, Detective Markowitz?
I'm a detective with the Denver Police Department.
Detective, could you please tell us how you are involved with this case?
Well, I was the detective assigned to investigate the death of Mackenzie Brackman, and I was also the responding detective after the police call made to Brackman's residence on Friday, March 6th of 2020.
Before we talk about your findings in this case, I'd like to discuss your background. What type of detective are you?
I'm a crime scene investigator specifically.
What type of training was necessary to become a detective?
Well, after working for the DPD for 6 years, I was qualified to become a detective. So in addition to completing police academy and having years of experience in the field, I became qualified to be a detective as well. And I've been working as one for about 7 years now.
Do you have any specific qualifications or training in other areas?
I do actually, yes. I have specialized training and experience with cell phones. I have a cell phone technology and data recovery certification from the American Academy of Law Enforcement.
What experience do you have in the field of cell phones?
Well, I use forensic software to download information from a cell phone, acquire and interpret call records, and obtain and interpret cell tower data. And I've used these techniques to download the contents from hundreds of cell phones and have used cell tower data in over 50 cases.
How do you use these records as a detective?
Well, the information from the cell phone data gives us detectives a lot of information as to where suspects are at a given moment, as well as their regularly conducted incoming or outgoing calls.
Your Honor, at this time, I would like to offer Detective Jordan Markowitz as an expert in crime scene investigation and the gathering and interpreting of data from both cell phones and cell towers.
Give me just a moment. Okay, and Ms. Hayden, we have an expert being requested to be qualified in crime scene investigation and cell phone operation and analysis and retrieval of information. Do you object to either or both of these qualifications?
No, I do not, Your Honor. I have no voir dire at this time. I'll address the shortcomings of this witness's investigation on cross.
Thank you. I will qualify Detective Markowitz as a crime scene investigator and in the area of cell phone operation, data retrieval and analysis. Ms. Hunt, you may proceed.
Thank you, Your Honor. Detective, let's talk about the evidence of this case. When did you arrive at the crime scene?
I first got there around 2:20 p.m. after the paramedics and responding officers had all finished their jobs and secured the scene.
What did you see at the scene initially?
Well, before entering the home, I observed the victim through the open front door where I saw Mackenzie Brackman deceased on the floor. There was a large pool of blood on the upper left back and shoulder and underneath the victim, as well as a large knife also covered in blood next to the victim's body, and it was clear from that they had been stabbed.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 1.
Yes, Exhibit 1.
I have one here.
Oh, thank you. Sorry. What is this a photo of?
Exhibit 1 is a photo of the victim, Mackenzie Brackman, deceased on the floor just past his front door.
Is this an accurate representation of the victim as you saw him?
Yes, it is.
Your Honor, at this time, I would like to offer Exhibit 1 into evidence.
And Ms. Hayden, any objection to 1?
Yes, Your Honor. I would say that the prejudicial impact highly outweighs the probative value of this exhibit.
Ms. Hunt?
Your Honor, that would be decided by the jury. This objection goes to the weight given to this exhibit, not its admissibility.
And Ms. Hayden, last word.
I disagree, Your Honor. The prejudicial impact outweighs the probative value.
I'm going to admit 1. It is, of course, prejudicial evidence. Question is whether it's unfairly prejudicial. This is a homicide. We're going to see blood and we're going to see a stab mark. The jury has to see those as elements of proof. Therefore, the objection's overruled. 1 is in. Ms. Hunt, you may proceed.
Thank you, Your Honor. Your Honor, permission for Detective Markowitz to now constructively view Exhibit 5.
5, yes.
Thank you.
I've got that exhibit in front of me.
Can you tell us what this exhibit is?
Yes, this exhibit is a photograph of the knife covered in blood that was on the floor next to the victim.
Did you take this photo?
No, I didn't. The forensic team did.
Based on what you saw at the scene, is it an accurate representation of the knife?
It appears to be, yes.
Your Honor, at this time, I would like to offer Exhibit 5 into evidence.
And Ms. Hayden, as to 5?
No objection, Your Honor.
5 is in. Ms. Hunt, you may proceed.
Thank you, Your Honor. Detective, did you enter the home?
Yes, I did. Upon seeing the victim, I walked around the side of the house and noticed that both the side gate and the back door were both open. So I entered the home through the back door, which took me into the kitchen.
What did you observe in the kitchen?
Well, I noticed that everything seemed pretty much intact, though there was a large knife missing from the knife block in the kitchen. And from standing in the kitchen, I could see the dining room where I observed both a broken plate on the floor as well as a knocked over chair.
Your Honor, permission for Detective Markowitz to constructively view Exhibits 8 and 9.
8 and 9, yes.
I'm viewing these exhibits.
Can you tell us what these exhibits show?
Yes, Exhibit 8 is a photograph of the knife block in the kitchen, and Exhibit 9 is a photograph of the broken plate that was on the floor in the dining room.
Are these accurate representations of both the knife block and the broken plate?
They are, yes.
Your Honor, at this time, I would like to offer both Exhibits 8 and 9 into evidence.
Ms. Hayden, as to 8, any objection?
No objection to either, Your Honor.
8 and 9 are in. Thank you. Go right ahead, Ms. Hunt.
Thank you, Your Honor. Detective, did you conduct any other analysis at the crime scene?
Well, I mentioned earlier that I walked around to the back of the house, and there I noticed ring cameras. So ring cameras are doorbell cameras that start filming anytime they detect motion. So after downloading the contents of Brackman's phone, I was able to access his Ring account to view any videos that the cameras had taken that day.
Were any of these videos significant?
Yes, actually, I found a few significant videos.
What did those show?
Well, they showed someone about the same size and build of the suspect here today, wearing a mask, hiding their face, as well as hooded clothing.
What was the person in the video doing?
The first camera picked them up attempting to open the locked front door, and once they realized it was locked, they then went through the back gate a few seconds later. 20 seconds later, the next camera picked them up at the back door coming inside the home, and finally the same front camera captured the suspect running out of the house.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 12?
Yes.
Detective, what does this video show?
Well, after walking through the back gate, the intruder then enters the house through the back door, and Exhibit 12 is the Ring camera footage from the camera that was pointed at the back door. It shows them entering the home.
What time was this video taken?
It was taken around 1:05 to 1:10 p.m.
Is this an accurate representation of the Ring camera footage that you collected through the victim's account?
Yes, it is.
Your Honor, at this time, I would like to offer Exhibit 12 into evidence.
And Ms. Hayden, any objection to 12?
Seeing that Detective Markowitz has already testified to the entire contents of Exhibit 12, I have no objection, Your Honor.
Fair enough, it's in.
Thank you, Your Honor. Finally, Detective, I would like to discuss any conclusions you may have come to through your conducted cell phone analysis.
Absolutely.
Did you obtain cell phone records?
Yes, I did. Becker's attorney provided me with the phone number for the phone that Ms. Becker claims to have lost, and I then got a court order to obtain call detail records from Becker's service provider and the cell tower records for March 6th of 2020.
What are call detail records?
Essentially, these are records that are kept to record when you place or receive a call or send and receive a text. So these records show both the date and time of the interaction, its status, which is incoming or outgoing, whether it was a call or a text, as well as its duration. And moreover, the record identifies which cell tower the phone communicated with, and it actually even tells us which antenna specifically the tower with the phone communicated with. So in most cases, almost 100% of cases, the phone connects with the tower nearest to it.
Your Honor, permission for Detective Markowitz to constructively view Exhibit 15?
15, yes.
I've got that here.
Great. What is Exhibit 15?
Exhibit 15 is a copy of the diagram showing the location of the cell towers that Ms. Becker's phone communicated with on March 6th around the time of Mackenzie Brackman's death.
Did you assemble this diagram?
I did, yes.
Can you tell us what information it summarizes?
This diagram essentially summarizes the call detail records of Becker's phone, and the records actually are voluminous.
Your Honor, at this time, I would like to offer Exhibit 15 into evidence.
And Ms. Hayden, do you have any objection to Exhibit 15?
No objection, Your Honor.
15's in. Ms. Hunt, you may proceed.
Thank you, Your Honor. In your experience, Detective, what does this diagram tell us about the location of Becker's cell phone?
Well, the CDRs, or call detail records, that I had access to show several calls and texts that were sent to Avery Becker's phone from another phone prior to the time that Brackman was killed. I later identified this other phone as that of Becker's friend, Taylor Perkins. And what the data showed was that no call was actually answered, which means that Perkins was calling Becker, but Becker wasn't answering. So if you look at the diagram, you'll notice that Becker received a text at 12:47 p.m. from Perkins through the tower covering Becker's house. So another text was sent 8 minutes later, again, with no response. And finally, there came two incoming, but again, unanswered calls at 1:05 and 1:06 p.m., followed by a text message at 1:17 p.m. And all three of these communications went through the antenna that was covering Brackman's residence.
And based off of these cell tower records, what opinions can you draw from this summary?
Well, based on my experience and my knowledge of cellular communication, it's clear that Becker traveled from her home on March 6th to Brackman's home and was there from at least 1:05 to 1:17 p.m.
And as a crime scene investigator, did you reach an opinion as to what occurred at the crime scene on March 6th around 1 p.m.?
I did, yes. Based on my use of reliable methods applied to the evidence of this case, it is my opinion that Becker was in the house only to be caught off guard by Brackman's presence, and Becker got a hold of the knife that Brackman had grabbed for self-defense and was unfortunately able to stab and kill Mr. Brackman.
Thank you, Detective Markowitz. No further questions.
I will pause for just a moment before we have cross-exam of Detective Markowitz. And Ms. Hayden, you may cross-examine Detective Markowitz.
Thank you, Your Honor. Detective Markowitz, when a criminal defense lawyer is violently murdered, your first assumption is often an ex-client, isn't that right?
Yes, and in this case, it actually was.
Are you testifying here today that an ex-client murdered Mr. Brackman?
Oh, no, your question was asking whether that was my first assumption, and it was in this case.
Okay. And in this case, your only suspect that you looked into was a high school girl who Mr. Brackman coached in mock trial. Isn't that right?
That was the only one that I mentioned in my witness statement.
And you made a prior statement in this case, correct?
I did, yes.
And you signed that statement?
I did, yes.
You signed that statement saying that you would include all relevant and timely information to this case, didn't you?
Correct, I did.
So regardless of whether or not you interviewed other suspects, you did not include them in your affidavit, did you?
That's correct. The only one that I mentioned in my witness statement is Avery Becker.
Right. And you knew Mr. Brackman prior to this case, didn't you?
I did, yes. I was actually the homicide detective in many of the cases that he has taken to court, yes.
And you went as far to say that Mr. Brackman was not very good at his job.
Well, it was, had to do with the way that he was acting towards the responding detectives on the case, but I would never let the way that someone conducts their own business get in the way of a trial about their own horrific and untimely death. I would never let that happen.
And let's discuss the day of the murder. You said that Mr. Brackman must have armed himself with his own knife, seeing that the intruder did not bring one. Isn't that right?
Yes, from the knife block that had the empty slot in the kitchen.
But you do not know if that intruder came with a knife, perhaps in their pocket or waistband or something like that.
It potentially could have been the case, but because of the empty slot in the knife block in the kitchen, it seemed to me, along with the other evidence, that it was the knife that Brackman used to defend himself.
Let's actually discuss that empty slot. Your Honor, permission for my trial technician to pull up Exhibit 8.
Yes, Exhibit 8 for introduction, yes.
Detective Markowitz, did the murder weapon match the knives in this knife block?
Let's first get I don't have 8. Oh, I do have 8 in evidence. My mistake. 8's in evidence. Go right ahead.
Okay, thank you, Your Honor. I'll ask again. Detective Markowitz, did the murder weapon match any of the knives in this knife block?
It actually didn't. It looked slightly different from the knives in this knife block, which would make sense considering it seems as though the biggest knife was one that was used frequently. So they may have had to, Mr. Brackman may have had to change it out.
And are there any other knives in this knife block that do not match the set?
They all appear to be the same.
So it is possible that the intruder brought the knife themselves and Mr. Brackman did not have a knife.
Potentially, but I do believe it's unlikely.
And you lost evidence in this case, didn't you?
Unfortunately, the files on the camera did become corrupted, and even someone who is an expert in technology unfortunately has issues with it sometimes.
And
so,
let's take Exhibit 8 down, please.
Oh, thank you. Yes, thank you. So photos of blood splatter, which showed the struggle that you claim occurred, were lost in this case, weren't they?
Unfortunately, those were part of the photos that were corrupted, yes.
Now, Mrs. Markowitz, you said that Mr. Brackman knew the intruder was coming, didn't you?
I believe so, yes.
And how would Brackman have known this?
Well, the Ring cameras actually are set up on Brackman's account to notify him if there is an intruder coming. So it could have been that way, or it could have been the noise that the intruder was making.
Is it your statement here in court today that Mr. Brackman's Ring notifications were turned on?
I believe so, but I cannot recall specifically.
So you cannot be sure that Mr. Brackman's Ring notifications were turned on?
It's a potential possibility. Unfortunately, looking back on the case as detectives now, we can't really know that for sure all the time.
But as you said, you are an expert witness in cell phones, so you didn't take the time to find out if the Ring alerts were on.
No, it's kind of gets a bit hazy when it comes to the Ring accounts, but yeah.
And you said yourself that cell phones do not always connect to the nearest cell tower, do they?
Not 100% of the time, but almost 100% of the time.
And that other percentage of time often happens when the tower that the phone is at is busy, isn't that correct?
Occasionally, yes, but in most cases, the phone does connect with the tower nearest to it.
If the tower is busy, the tower may cover a range somewhere like a mall. Doesn't that make sense?
Yes, potentially, if the mall is in the 120-degree arc of that cell tower.
So the cell tower data could mean entirely nothing about the location of Avery's phone on that day.
Only if the cell tower is covering, like you say, potentially a mall. However, it is most likely, and in most cases, almost 100% of the time, it is that the phone will connect with the cell tower nearest to it.
And let's discuss those specific cell tower arcs. Your Honor, permission for my trial technician to pull up Exhibit 15, I believe was already entered.
15 is admitted. Thank you.
Okay. Detective Markowitz, I know the font is pretty small, but can you see that there is actually a third location marked on Exhibit 15?
Yes, I do see that.
And what location is that?
It says Rollins's house.
And that is in the exact same cell tower range as Avery Becker's house, isn't it?
It appears to be, yes.
So, as you said, you gave an affidavit in this case. Did you include Blair Rollins in that affidavit?
No, because considering the other evidence is in this case, which is what a good police officer does, it was clear to me that all of the evidence did in fact suggest that this was Becker's cell phone and it had come from Becker's home, not Rollins's.
Evidence that you use like this CDR data, which clearly has Blair's house marked on it, correct?
This does have Blair's house marked on it, yes.
That's enough of that exhibit. Thank you so much. Detective Markowitz, you looked into Avery because of some text sent between Alex Cifuentes and the defendant, isn't that right?
That was the first lead that I took in the case.
And the only evidence that you have of this interaction between the two is actually screenshots sent to you by Alex Cifuentes.
Yeah, unfortunately, I'm assuming it was just the nerves of having to come down and meet with a police officer, which is understandable, but Ms. Cifuentes did not bring her phone with her that day, so I used the screenshots that she sent me.
Because you never looked through Cifuentes' phone, it's possible that Ms. Cifuentes forged these texts, isn't that right?
I will say it is difficult for someone, say, of high school level to be able to do that.
Objection, Your Honor. Speculation.
And Ms. Hayden?
I objected. I'm sorry, Your Honor.
Oh, I'm sorry.
No, you're right.
Wait a minute.
I objected to what the witness was testifying to.
Oh, that it was so you're asking the court to strike that testimony. I'm sorry.
Yes, Your Honor.
I have to admit I was looking down and I
that is okay.
assumed it was an objection, although it would have been a strange objection from the prosecution.
We got the H last names. It makes sense. No worries.
But the proper objection then is that you wish me to strike that testimony. Ms. Hunt, what is your position?
Your Honor, may my witness rephrase her answer to the question?
Of course.
I'll ask it again.
Question re-asked?
Sure.
Yes.
So, Detective Markowitz, if Alex Cifuentes had forged these screenshots, you would not know.
I do say it's highly unlikely that she did, but you know, again, even without these screenshots, there's ample evidence to suggest that this was Becker. It's not solely a case built off of these screenshots.
Ample evidence like the CDR records, isn't that right?
Yes, and other witness testimony, correct.
So as you said, you are an expert in cell phones, yet you chose not to download the contents of Alex Cifuentes' phone to verify this conversation, did you?
No, I didn't see it needed. I had the other evidence that I needed.
Nor did you think to do any investigation of Taylor Perkins's phone, which would have confirmed or denied Avery's alibi, wouldn't it have?
No investigation that I mentioned in my witness statement.
So just to confirm, you cannot prove that Avery ever sent Alex Cifuentes a single text.
Well, I do, again, think it's highly unlikely that Cifuentes was able to somehow forge these text messages.
Your
but
Honor,
even without,
I already had this testimony stricken from the record.
No, but I'll allow you to make an argument on it, but the earlier was for her testimony that a person of her age could not do that. Now she just said it's unlikely based on her expertise. So do you still have that? Do you still wish that testimony stricken?
I believe, Your Honor, that the detective said that Alex Cifuentes did not have the expertise to Photoshop these. So yes, I do.
And Ms. Hunt?
Your Honor, counsel's question calls for speculation by my witness. I'm unsure why we would need to strike my witness's testimony from the record. She be afforded the ability to rephrase the question and rephrase the answer in a way that's not calling for speculation.
If Detective Markowitz can provide a foundation for her opinion of the difficulty of doing this, being an expert in the area, she may do so. Otherwise, I will strike the testimony. So detective, it's up to you.
I'll re-ask the question. Detective Markowitz, can you or can you not definitively prove that Avery Becker ever sent Alex Cifuentes a single text?
Based off of the screenshots, which I do believe are valid, it's hard to say for 100% certainty, but nearly 100% certainty she did.
Thank you, Your Honor. No further questions.
And we'll pause a moment before redirect. And Ms. Hunt, you may redirect your witness.
Detective, what was your interaction with Alex Cifuentes like?
Alex was incredibly helpful the entire time during the interview. Granted, she was nervous, which is understandable, but she was incredibly willing to help figure out what had happened, especially considering she did have a lot of good feelings towards Mr. Brackman.
Did you ever see her phone?
No, unfortunately, I did not physically see her phone.
And why didn't you look at the actual text messages?
Well, I found that with all of the other evidence in this case, it wasn't actually entirely necessary for me to do so. All of the evidence was pointing to Becker regardless of the screenshots.
Thank you. No further questions.
And we'll pause a moment before recross. And I just remind counsel, if all the witness and both counsel involved in examination, leave your mics active. It just means you don't have to do that one extra step if there's an objection or something. So Ms. Hunt, you can open your line up. There we go. And Ms. Hayden, you may recross if you wish.
I don't have a recross, Your Honor. Thank you.
Thank you, Detective Markowitz. You are excused. Thank you very much. We will pause a moment before we have the prosecution's third witness. Let the scoring jurors catch up a moment. Thank you. And Ms. Amon, if you would call your next witness for the prosecution.
Yes, Your Honor. The prosecution calls Kyle Cusack to the stand.
And we have Ms. Murphy for the defense. Mr. Cusack, if you could introduce yourself with your character name and of course your student name.
Yes. Hi, my name is Drew Filerman, and today I am playing Kyle Cusack, K-U-Z-A-K.
And Mr. Cusack, could you please raise your right hand? Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ms. Amon, go right ahead. Your witness.
Thank you, Your Honor. Will you please introduce yourself for us?
Yes, my name is Kyle Cusack, K-U-Z-A-K.
And what do you do for a living?
I am a crime scene reconstruction investigator, or a CSR for short, and I work for the city of Denver. I'm also certified by the Colorado Bureau of Investigation.
What does a CSR do?
CSRs investigate crime scenes as well as review photographs and video evidence of crimes. I always assume that all cases will go to trial, and I also organize and document my evidence to make reconstruction for a scene easier later on.
How long have you been a CSR?
I've been a CSR for 19 years.
What have you done in that time?
Well, in my time, I've had a lot of experience with complex crime scenes, like home invasions and burglaries.
As a seasoned CSR, how are you connected with this case?
Well, I visited the scene of the crime and reviewed police reports for the case. I also looked at photographical evidence, video footage, as well as the autopsy report.
Based on your investigation, did you come to a conclusion?
Yes, I did.
How exactly?
As always, I let the evidence guide me to my theory. Specifically, I used Tom Bevel and Ross Gardner's seven-step methodology for event analysis.
How do these processes work?
Well, I review contextual information using a step-by-step process. I note relationships between the evidence in order to help form the chronology of the case. This is what I've always done, and it's proved to be very reliable.
Your Honor, at this time, I now offer Mr. Cusack as an expert in crime scene reconstruction.
And Ms. Murphy, any objection to that qualification?
No, Your Honor. All questions regarding the credibility of this witness will be addressed on cross.
Thank you. I will qualify Mr. Cusack as an expert in crime scene reconstruction. Ms. Amon, you may proceed.
Thank you, Your Honor. What is your expert opinion on what happened on March 6th?
This was a burglary that clearly got out of control.
Can you walk us through the steps that got you to this opinion?
Yes, so the very first piece of evidence that I looked at was the Ring doorbell video footage.
Why did you look at the Ring doorbell?
Well, Ring doorbells are a form of surveillance, which is essential to crime scene reconstruction.
What did the footage show?
The footage showed somebody entering the home via the back door.
What occurred based on the evidence once the intruder got inside?
The intruder and Mr. Brackman encountered each other, and logically being notified of their presence with the subscription that Brackman had, Brackman then armed himself with a knife from his chef block.
How do you know he was armed with a knife?
Well, there was an empty slot in the kitchen knife block, and it matched up perfectly with the knife recovered from the victim's body.
And based on the evidence, what happened after this?
Well, there was clearly a struggle between both parties, and the two met at the back door and then made their way to the kitchen, knocking over a plate.
You mentioned earlier you reviewed Mr. Brackman's autopsy report. Would you recognize this now?
Yes, I would.
I would like to now direct your attention to Exhibit 19. What is it?
This is a copy of the autopsy report that I reviewed as part of my case.
How did you obtain this record?
Well, a coroner is a public official, so an autopsy report is therefore a public record, and thus it's available to anyone.
And why did you review it?
Well, I just wanted to be as informed as possible, and I needed to find out anatomically just how Mr. Brackman died.
Your Honor, I now offer Exhibit 19.
And Ms. Murphy, any objection to 19?
No, Your Honor.
19 is in. Thank you. Ms. Amon, you may proceed.
Thank you, Your Honor. Okay, now briefly, what does this autopsy report show?
It establishes that the knife was lodged into the victim's shoulder blade, meaning the two must have been in some kind of bear hug position, and the intruder reached over and stabbed Mr. Brackman in the upper back. It also showed how the knife would have entered the body.
What do you mean by that?
Well, the knife entered face downward and partially forward. And I know that the defense expert Van Owen sees this as unlikely, but I disagree.
Who is Van Owen?
Van Owen is the defense expert on this case, and I reviewed Van Owen's theory in order to be as informed as possible.
And how did this theory alter your opinion?
It didn't.
Why not?
So I will admit that some of her opinions are out of my expertise, but I do know that Van Owen is not a CSR. So Van Owen can only read reports and use those reports to base their opinions, which is a lot different than actually being at the scene of the crime.
Now, through your investigation and review of Van Owen's theory, what events caused the death of Mr. Brackman?
An intruder entered Mackenzie Brackman's home. Brackman was alerted by his Ring app and armed himself with a kitchen knife. The two then got into a struggle. The intruder grabbed the knife and stabbed Mr. Brackman, leaving him to bleed to death. This was a burglary that clearly just got out of control.
Thank you. No further questions.
Thank you. We'll pause a moment before cross. And Ms. Murphy, you may proceed with cross-examination.
Good afternoon, Mr. Cusack.
Good
You say
afternoon.
that you approach crime reconstruction in 5 steps, correct?
Yes, that's correct.
Let's go through that process one by one. When you arrived at the scene to complete your recognition and documentation step, the crime lab had already processed the evidence, correct?
Yes, part of my job is to reconstruct the evidence after it's already been processed.
Which means that you didn't have fresh eyes on the crime scene.
No, that's not part of my job. I don't look at it initially.
So the evidence could have been ruffled around with and you wouldn't know because you didn't see the crime scene firsthand.
It's not likely that the evidence was messed with or tampered with.
But it's possible.
Well, these are professionals, so I'm not sure that they would do that, but It is possible, yes.
The second step in your process was the collection of evidence, correct?
Yes, that's correct.
However, in all your apparently meticulous work, the digital files for the photographs of the crime scene became corrupted.
The file corruption took place much after I had reviewed the photos, so I didn't really have anything to do with that.
But this means that the photograph evidence that the jury will review today is not an accurate depiction of the crime scene.
It might not be, but again, it was not my fault, so.
In addition to the corrupt photos, you also managed to lose images of the blood drops and their cast-off splatter during your collection of evidence.
I didn't lose them. The file corruption, again, took place after I had
So
reviewed.
someone on your team lost them.
Yes, I think that is what happened, yes.
And they are not here today for the jury's review so that they can render a fair verdict?
Not that I am aware of, no.
The third step in this process was the evaluation of evidence, correct?
Yes, that is correct.
And in this process, you analyzed the scuff marks in Mr. Becker's home?
Yes, I did.
Sorry, Mr. Brackman's home.
Yes.
And in your evaluation, you determined that this evidence indicated a fight between the intruder and Mr. Brackman.
Yes, it indicated that they were in some kind of struggle.
And you never make assumptions without evidence, correct?
No, I always let the evidence guide me to my theory.
Yet you assumed these scuff marks indicated a fight when they could have been created at any point, correct?
Well, considering the circumstances that a burglary and a murder took place, it is very, very fair to assume that these scuff marks were made during that struggle.
But carbon dating was not possible at this time, which is the only way that would determine the true time these scuff marks were created. Am I correct?
Yes, you cannot carbon date scuff marks. However, I am pretty sure, yes.
But for all we know, those scuff marks could have been created a year ago when Mr. Brackman just came back from a hike.
Hypothetically, but not likely.
Secondly, in your evaluation of evidence, you determined that the Ring doorbell notified Mr. Brackman of the intruder.
Yes, that's correct.
Yet you again assumed Mr. Brackman had his notifications turned on when they very well might have been turned off.
Well, I assume he would always have his notifications on if he's paying for that subscription.
Right, you assumed. And you didn't take the time to confirm your theory by checking Mr. Brackman's Ring doorbell?
Well, again, because he has the subscription, I felt like he would have clearly been notified. So
you assumed.
Objection, Your Honor. I would ask that opposing counsel would please allow my witness to finish their answering the question.
Sorry, Your Honor. Yes, I'll allow him to do so.
Very much. Let's proceed. Thank you.
I did not feel the need to check, no, because since he was paying for this subscription, it's pretty logical to assume that he would have been getting these notifications.
So like you said, you assumed.
Yes, technically I assumed.
Then your fourth step was hypothesis and testing, then reconstruction, correct?
Yes.
Now you say that after completing this step, that the evidence you collected could only lead you to one conclusion.
Yes, the evidence helped me formulate this theory that I have created.
So you knew this case for sure if it led you to a solitary conclusion.
Yes, I knew this case very well, and all of the evidence did point to one thing.
Just like you were confident in your recollection of lost and corrupted photographs?
Again, lost and corrupted photographs that happened far after I had reviewed them.
Just like you were confident in the Ring doorbell notifications?
Yes, the notifications that he logically would have been receiving.
And just like you were absolutely confident in your analysis of the scuff marks?
Yes, I am very confident in my analysis.
Thank you, Mr. Cusack. No further questions, Your Honor.
Thank you. And we'll pause a moment for before we have redirect. Could we have a time check on redirect, please?
I have 30 seconds left.
Thank you. And Ms. Amon, you may now redirect your witness.
Mr. Cusack, I have one really quick question for you. How do you come to your conclusions?
I always let the evidence that I have reviewed at the scene of the crime let me form my theory. You know, I never go into a case having a pre-established theory in mind. I always have to let what I see in front of me determine what I believe.
Thank you. No further questions, Your Honor.
And a moment before we have recross. And could we have a time check on recross, please?
1 minute left for recross.
Thank you. And Ms. Murphy, you may recross.
I do not have a recross at this time, Your Honor.
Thank you. Mr. Kuzak, you are excused. Thank you very much. Do we have any additional witnesses for the prosecution?
No, Your Honor.
Does the prosecution rest?
Yes, Your Honor.
We'll have just a minute before we have the defense case and let our scorers catch up. And if we could have the first witness for the prosecution and the attorney doing the examination.
Your Honor, do you mean the defense?
Oh, did I say prosecution? Thank you.
Yes.
Yes, for the defense. And Ms. Murphy, you'll be doing the first witness?
Yes, Your Honor. The defense calls Professor Van Owen to the stand. Good evening, Professor Van Owen. Would you please state...
Hang on just a second.
Excuse
I'm
me.
sorry. I just had a little paperwork to do here to make sure I have all witnesses and all attorneys checked off. Ms. Murphy, there we go. And we have a witness on the stand, Ms. Van Owen. And if you could please introduce yourself first for the court, including your character name and your student name.
Hello, my name is Professor Blake Van Owen. That's spelled Van-O-W-E-N. And my student name is Lily Humber.
And Professor Van Owen, if you please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ms. Murphy, go right ahead.
Good afternoon, Professor Van Owen. Would you please state your full name and spell your last for the record?
Hello, I'm Professor Blake Van Owen, V-A-N-O-W-E-N.
And what do you do for a living?
I've worked for the Aurora PD as a security guard and as a school resource officer. Now I'm a professor. My journeys have led me to a community college, and now I work at CU.
Where did you receive your education?
I received my bachelor's in English right here in Colorado at Boulder, and my master's in criminal justice from Ashford University.
What courses do you teach as a professor?
Mostly police procedures, police practices, and most importantly, social justice.
Have you ever used your experience to testify as an expert witness?
Absolutely. I avail myself regularly as an expert courtroom witness. I've consulted on over 100 cases thus far. I've also been an expert for courts in 6 different states. I get to use my expertise everywhere from the canyons to the Rockies.
What areas have you testified to as an expert witness?
I testify to crime scene reconstruction, cell tower analysis, and general police practices.
How many times have you testified in each of these areas?
So crime scene reconstruction 8 times, cell tower analysis 5 times, and general police investigation 12 times.
What are the methods that you use to determine the facts of a case?
Anything, ranging from police reports, crime scene reconstruction, and cell tower reports.
Did you use these methods and your prior expertise to conclude your investigation in today's case?
I absolutely did. It's like you're talking to a beekeeper about bee care, honey extraction, and hive construction. This is the wheelhouse of my expertise.
Your Honor, because of Professor Van Owen's extensive experience as a defense expert, the defense would like to enter Professor Van Owen as an expert witness in crime reconstruction, cell tower analysis, and general police practices pursuant to Rule 702.
And Ms. Amon, we have 3 areas that Professor Van Owen is requested to be qualified in: police procedures, crime scene reconstruction, and cell phone analysis. Are there any or all of those that you object to her testifying to as an expert?
Do I have permission to conduct a short voir dire?
Yes, you may.
Thank you. Professor, you have no training in the field of crime scene reconstruction, isn't that right?
My training is from working in the field for many years. However, I have no formal training.
Thank you. And you have no education in this field, correct?
I have education in criminal justice, and my education comes from working in this every single day. It's a learning process.
I'm trying to keep this short, so I'd appreciate if you could also keep your answers short. Is that a no,
my
you
best.
have no education in the field?
I have no formal education in the field, no.
Thank you. And you're not certified as a crime scene reconstruction investigator or crime scene reconstruction?
No, I'm not officially certified.
And you've never worked as a CSR, right?
No, I have never worked as a CSR.
And you've never reconstructed a crime scene?
No.
Your Honor, at this time, I object to Professor Van Owen as being availed as an expert in crime scene reconstruction, but not the other two areas.
And okay, so as to cell tower analysis, you have no objection, or
No,
as
Your
police
Honor.
procedures, no objection, correct?
No, Your Honor.
All right, she will be qualified in both of those areas. As to crime scene reconstruction, I would ask Ms. Murphy, if you could inquire of the witness. I thought she did reconstruct this scene, not formally for the police or as a certified reconstructionist, but I thought she indicated in her testimony when you asked her questions that she did do crime scene reconstruction. Could you ask that question?
Yes, Your Honor. Professor Van Owen, did you reconstruct this crime scene in this case?
I did reconstruct this crime scene. Additionally, as an expert witness in a courtroom, I have testified for crime scene reconstruction 8 times.
All right, now Ms. Amon, do you still make that objection?
I still object.
Okay, I will qualify Professor Van Owen in the final area of crime scene reconstruction, although she doesn't have a certification formally or any formal education experience under the rule, can qualify as an expert. Her credibility and her procedures will be judged by the jury, not by the court. She is qualified. Ms. Murphy, you may proceed.
Thank you, Your Honor. Professor Van Owen,
sorry,
have you reviewed the police's opinion in today's case?
I have, backwards and forwards.
Do you agree with their opinion?
I disagree wholeheartedly. Numerous areas were either overlooked or completely botched.
Which areas in the investigation were overlooked?
Well, I've organized their flaws into 3 categories: the attack, the opportunity of the intruder, and the carelessness in the collection of evidence.
Let's look further into those points. Could you start with the first one, the attack?
Certainly. The police believe that the victim anticipated the intruder's attack, and there was some sort of struggle between the two. This was based on, get this, Ring doorbell alerts and scuff marks on the floor.
Were these reliable indicators?
Absolutely not. The police failed to see if the victim even had ring alerts. It was a very simple check, but the prosecution just assumed they were on.
Can you elaborate on the scuff marks that you mentioned previously?
The prosecution never even dated the scuff marks. They have no idea when they were made or where they are from. Without this information, they are just scuff marks of doubt.
In lieu of this information, what did you find to be the most likely scenario?
The victim was clearly sitting at the table, unaware of the intruder. The intruder stabbed him from behind and ran.
The second point that you mentioned was the opportunity of the intruder. Why did you find the police overlooked this area?
Well, for one, the height of the intruder was just entirely disregarded.
Why does the height matter?
If you look at the photos, the victim was clearly a large, full-grown man. For the prosecution's theory to work, the intruder would have to be standing above him to stab at that angle. While Avery, while the victim was upright, could clearly not stab a full-grown man.
Were there any other details in this area that the police miscalculated?
Yes, the police relied on unpredictable cell tower reports.
Why are they unpredictable?
Think of a cell tower like a glass of water. When one glass gets too full, you move on to the next. Same goes for cell phones. When one tower doesn't provide the next signal, they move on to the next. This connection is impossible to predict. A phone could sit under a sofa for hours and connect to several different towers.
Why is the cell tower information crucial?
The prosecution assumed that this map could show the location of Avery. But as I said, cell towers work nothing like a GPS, and phone GPS data was not provided by the prosecution.
The third and final point that you mentioned was the carelessness in the collection of evidence. Could you elaborate?
On top of everything, photos of supposed blood drops around the house were corrupted. The prosecution entirely lost a set of evidence from the crime scene.
Is there any other information that the police did not investigate?
The prosecution failed entirely to consider other suspects, specifically Blair Rollins.
Who's Blair Rollins?
Blair is a former CHS student. Her father was sent to jail after the victim
Objection, relevance.
And the objection is
Relevance, Your Honor, for 401 and 402.
as to Blair's relevance to the case?
As to the father being sent to jail.
I'm sorry, the father being sentenced. Ms. Murphy, what is the relevance of that evidence?
It shows that Mr. Blair Rollins, he had a motive to kill Mr. Brackman, and it also shows the police's negligence in this investigation.
And Ms. Amon?
To the fact that Mr. Rollins had some sort of personal vendetta against Mr. Brackman, we do not know. There's no way to prove that this feeling of the father would be able to have been translated to Blair and thus give him a motive. So it's still irrelevant.
Ms. Murphy, last word.
I still think that this is very crucial, and it's for the jury to decide whether it is relevant to the case or not.
I'm going to overrule the objection, although the motive may be slim, it is still a possible motive that defense can argue that the police should have followed up on. That's for the jury to determine whether it would be reasonable to follow a lead that was slim or not slim. That's their determination. Overruled. You may continue. If you need to re-ask the question, that's fine.
I'll ask the question again, Professor Van Owen. So who is Blair Rollins?
Blair is a former CHS student. Her father was sent to jail after the victim represented him in trial.
Was Blair questioned by the police?
Blair was not questioned by the police. Let me say that again. Blair, someone with a motive against the victim, was not located or questioned by the police.
Overall, what were your conclusions about the police's investigation?
Simply put, the police have no files, no phone, and no felony. This investigation was rushed, and Avery Becker has been wrongfully accused.
Why are the 3 key details that we discussed today important?
These points are the foundation of the prosecution's case. They're as pivotal as the axle of your car when you're going 90 miles an hour. If you're going to put someone on trial for murder, you better make sure every detail is correct. The details of the prosecution are just far from correct.
Thank you, Professor Van Owen. No further questions, Your Honor.
I will pause just a moment before we have cross. And Ms. Amon, you may cross-examine Professor Van Owens.
Thank you, Your Honor. Professor, I would like to start by talking about your qualifications. You prepared a statement for us prior to your coming here today, correct?
I did, yes.
And you had the ability to alter this statement and provide any relevant information prior to coming today.
Absolutely.
Could you point to me where in your statement it says that you reconstructed this crime scene?
Let me find it. I have right here, I have on line 60, I have reviewed the police reports, the crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz. If you look at those 3 items, I did reconstruct something, a scene relevant to this criminal case.
Well, it says that you reviewed the police reports as well as the crime scene reconstruction done by Kyle Kuzak, the crime scene reconstruction investigator. Yet you yourself never state in this statement that you reconstructed this crime scene. You reviewed evidence, correct?
If you want to get technical, then yes, I did review a Kyle Kuzak's faulty crime scene reconstruction. However, I reconstructed those 3 values that I just listed of the case.
As a professional, I would hope you'd also want to get technical. So let's look at your investigation, or I'm sorry, not investigation, your review of the evidence. You're versed in the field of policing, correct?
I am.
And you would know under policing, there's generally crime scene reconstruction and cell tower analysis and general police investigation, right?
Absolutely.
With that in mind, let's take a look on your thoughts. I would like to start with the next piece, or start with Detective Markwitz's cell tower opinions. That falls squarely under the expertise of cell tower data, correct?
I'm sorry, could I have permission to pull up the exhibit you're referring to?
You may if you wish.
Thank you so much.
Of course.
And could you restate the question?
Yeah.
I believe that's exhibit 19, is it not?
No, I believe it's 15.
15, sorry. Exhibit 15, just so the jury knows what we're looking at.
Yes.
I have it in front of me.
All right, wonderful. So my question is that cell tower data falls squarely under one of your specialties, correct?
Yes, it does.
And you claim that Markowitz only subpoenaed information from a limited time and of Avery's phone, right?
Correct.
She didn't attempt to gather any information from other windows, other people's phones, right?
She did not provide any of this information, no.
And you didn't try to look into any other information of a larger window or of someone else's cell phone, right?
I consider it the job of the person with the burden of proof. However, no, I did not.
We're not really talking about the burden of proof in the prosecution. We're more talking about what you did today. So you didn't attempt, although being an expert in cell tower data, to look further into this.
No, I did not need to.
So you really just saw what you believed was a flaw, didn't really want to find out what the evidence showed, just wanted the police to look bad, right?
Correct. I found police faults in the report.
And you didn't try to find anything else about that. Moving on to the murder weapon. Now,
was there a question there?
I'm sorry, I forgot to ask at the end. I will restate.
All right, the jury will disregard the comment by counsel. There was no question. Let's have a question.
And so, yes, you didn't attempt to look further into this.
I did not look further into the cell tower records in this case, as that was the job of the prosecution.
Okay, so that's a no, right?
No.
And now the murder weapon. Now you claim there's a possibility that this knife was brought onto the scene of the crime, right?
Just to make sure you know, I'm looking at Exhibit 5, which you have entered. And it definitely a possibility that this is brought on to the scene.
What evidence showed you this?
It's more about what evidence didn't show that it was from on the crime scene. This knife was not consistent with anything that was in the drawers of the victim.
So you didn't actually bother looking into the murder weapon?
I looked into the murder weapon. It's right here, and it is inconsistent with the ones in the drawer of the victim and on the knife block.
And you have no proof that this was not taken straight from Mr. Brackman's home, right?
I don't have any direct proof. However, it is inconsistent and very unlikely to just have one stainless steel knife.
So no, there's no proof?
I have no direct proof, no.
Thank you. I would now like to talk about the notifications on Mr. Brackman's phone. You discussed that the police didn't look into the ring subscription of Brackman's phone, right?
No, Detective Markowitz did not offer any proof of this.
And yet you yourself didn't investigate any further?
No, I didn't need to. My theory is that there were no ring alerts.
Right, you didn't need to, because I mean, in all honesty, having this information wouldn't really provide us with as much clarity as one would hope. Isn't that right?
Correct.
So all you did in pointing this out was just trying to critique the police, right?
That is, in fact, my job, to look at the police and see where they made errors in a murder investigation.
Right. Your job is to reveal where the police dropped the ball. Isn't that right?
It is. I am a check on the power of police. Let me emphasize check. I see where if they did anything wrong.
Thank you. No further questions, Your Honor.
I will pause a moment before redirect. And Ms. Murphy, you may redirect your witness.
Thank you, Your Honor. Professor Van Owen, did you conduct a thorough and extensive investigation?
As I have with my over 100 trials of experience, I absolutely did.
Thank you, Your Honor. No further questions.
And we'll pause just a moment before recross, if any. And Ms. Amon, do you have any recross for this witness?
Yes, briefly. Professor Van Owen, you just said that you completed an extensive investigation. Isn't that right?
Yes, I extensively created this report.
Are you sure that you didn't actually create a partial investigation of the evidence?
I created a complete investigation of the police's work and a partial investigation on my own behalf.
Okay, thank you. No further questions.
Thank you very much. And Professor Van Owen, you are excused. We will wait just a moment before the defense second witness. And for the defense, could we have counsel call the next witness?
Yes, Your Honor. The defense calls Avery Becker to the stand.
And Ms. Hayden for the prosecution, Ms. Hunt for the, Ms. Hayden for the defense, Ms. Hunt for the prosecution, and our witness is the defendant, Avery Becker. Give me just a moment. And if you could, we do have the defendant on the stand. If you could state your character name and your actual student name, please, ma'am.
Yes, my name is Saffron Bennett Spurlock, and today I am Avery Becker.
Thank you. And Ms. Becker, you are the defendant and have been accused of a crime. And I need to make sure that you are aware of your right under the Fifth Amendment to the United States Constitution that you need not testify. You have the right not to testify or incriminate yourself. Are you aware of that?
Yes, Your Honor.
And by taking this stand, you know that you would be waiving that right, voluntarily, with knowledge, waiving that right. Is that correct?
Yes, Your Honor.
All right. If you please, Ms. Becker, raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ms. Hayden, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Becker. Would you please state your full name and spell your last for the record?
Avery Becker, Beckerer.
And how did you know Mr. Brackman?
Mr. Brackman was my mock trial coach while I was a student at Colorado High School.
Could you describe your relationship with him?
Unfortunately, Mr. Brackman and I didn't always get along very well. I loved mock trial and I was good at it too, but Brackman always seemed to think I was lazy just because I didn't need to prepare very much. I guess when it comes down to it, we just didn't really see eye to eye and we're pretty different people.
And would you say that Mr. Brackman was a good coach?
In my opinion, not really. Mr. Brackman was always very controlling and demeaning. It was awful at certain points, but like I said, we were just different people.
And how did you know Taylor Perkins?
Taylor Perkins is my best friend. We decided to do mock trial together as a way to hang out with one another more often and get out of the house.
So last year you were a senior in high school. How did your mock trial season go?
Unfortunately, not great. Mr. Brackman assigned me the role of crossing the expert witness and of doing the closing, which are both big roles, but that didn't seem to stop him from trying to completely take over everything and rewrite the part.
And what happened before the regional tournament of last year?
Well, about a month before the regional tournament, I showed up at practice only for Mr. Brockman to once again go off about how he didn't think I'd prepared enough. It was a little bit ridiculous. Yeah.
And so what did you do?
Well, I was pretty upset at the time, and I reported that he couldn't always keep taking credit for everything, and I actually ended up getting demoted to B team.
So what happened?
Well, like I said, I was upset at the time, but Taylor, who honestly wasn't all that into mock trial anyways, she came up with the idea that if she quit the team, Mr. Brockman would be forced to let me back on A team, and luckily he was, so everything worked out.
So did you end up competing in the regional competition?
I did, yeah.
And how did it go?
It went great. Mr. Brockman put me back on the A team in my original spots, and it was amazing. I won best closer and best attorney.
Did all these accolades change how Mr. Brackman treated you?
Unfortunately, no. The very next Tuesday after the regional competition, Mr. Brockman was back to his same self. He said that I didn't deserve the awards I'd received and that the team's victory was only thanks to the scripts that he had practically written. He even said that I was just lucky and only used my good looks to get by.
And what did you say?
Well, I retorted that he couldn't keep taking credit for all of our work constantly, and I was pretty upset, so I actually ended up storming out of practice.
And what happened when you stormed out?
Well, when I got outside of the parking lot, I was holding what I honestly believed to be an expo marker, as I'd been about to take notes on regionals at the whiteboard.
And what did you do with that marker?
I did the dumbest, most immature thing I've ever done, and I totally regret it. I used what I thought to be an expo marker to write on Mr. Brockman's car, worst attorney award. I guess I just didn't think it through because I had no idea it was permanent, but regardless, it never should have happened, and I feel awful about it.
And how did Mr. Brackman react to this?
Well,
speculation. Objection, speculation.
And to the reaction by Mr. Brackman, is that the objection?
Yes, Your Honor.
And Ms. Hayden?
Wait, was it to the question or to Mr. Brackman's reaction?
Well, it's a question asking about Mr. Brackman's reaction. That's the objection. That it is speculation. What's your position?
Yes, Your Honor. I'm not asking this witness to testify to the inner thoughts or feelings of Mr. Brackman, simply to her rationally based perception of events.
And Ms. Hunt?
I stand by my objection.
Objection is overruled. As the question was posed, it was merely as to the perception of the witness. Again, overruled. You may re-ask the question, Ms. Hayden, if the witness needs it.
Would you like me to re-ask the question, or should we move on, Ms. Becker?
Would you mind re-asking it, please?
Yes. So how did Mr. Brackman react when he saw that you had written on his car?
Well, Mr. Brackman then walked out of the parking lot. I think he was trying to talk to me about the argument we just had, but when he saw the car, he exploded, yelling at me that I was off the team for good and even calling Taylor a loser.
So what happened when you got home that night?
When I got home, I was sobbing. I guess you could say I was pretty outraged about the whole situation. And I decided to go talk to my mom because I was just so upset that my mock trial career was over and that I'd been, ousted from the team. And even though I was really upset, my mom, as she always does, just helped me to calm down and convinced me that the best thing to do was just to stay in control and not let anything get out of hand and just apologize the next morning.
So based on your mother's advice and sort of with time and hindsight, how do you feel about this incident?
Well, almost immediately, I felt awful about the whole thing, and that outrage quickly disappeared. I went to Mr. Brackman's office to apologize, and I even texted him. I offered to scrub his car. I even offered to get a job to pay for repainting.
And Was Brackman ever able to accept your apology?
No, unfortunately, Mr. Brockman refused to see me in person and he never answered my texts. I just feel terrible about it and I'd wish I had the opportunity to make things right with him.
What happened on the evening of March 5th?
On March 5th, Taylor and we went to the Fry Shack where we saw a bunch of the other mock trial kids, including Alex Fuentes. We just played games on our phones and then went to the mall to walk around.
And what is your relationship like with Alex Fuentes, who you mentioned?
Alex Fuentes and I are not friends whatsoever. We've never really gotten along and we don't spend time together. We don't really talk. Yeah.
During your senior year of high school, would you say you texted Alex Fuentes often?
Never. I heard Alex lie earlier and say that I texted her trying to get back on the team, and even that I said I was going to trash Brackman's house, but I never did either of these things. I would never text Alex for any reason because we just weren't friends, let alone to say something as awful as that.
So you're saying that Ms. Fuentes' statement is not correct?
Absolutely. I have never texted Alex.
And so what happened when you woke up on the 6th after going to the Fry Shack on the 5th?
Yes, when I woke up on the 6th, I remember immediately noticing that my phone had gone missing.
And so what did you do about it?
Well, I knew that the last time I'd seen it was most likely the Fry Shack or maybe the mall. So I picked up Taylor and we decided to go look for it. We, walked around the Fry Shack and the mall and kept using Taylor's phone to call mine to hear it ring. But every time we called it, it just went straight to voicemail, which honestly led me to think that either the battery was dead or it had been stolen.
Ms. Becker, do you know who Blair Rollins is?
I do. Blair Rollins is a student who went to the high school, Colorado High School, around the same time I did.
And do you know if Blair knew Mr. Brackman?
Blair, objection, speculation. This question is calling for speculation.
Well, the question is asking for the foundation, whether she knew. We can go from there. If she does know, maybe there's another objection on another question, but not this one. Overruled. Ms. Hayden, you may re-ask the question.
Ms. Becker, are you aware of Blair Rollins and Mr. Brackman's relationship?
Yes, Blair Rollins definitely knew Mr. Brackman. Mr. Brackman was the attorney that lost the case that got Blair's dad sent to jail.
And do you know where Blair Rollins is now?
No, I don't think anybody really knows. Blair just kind of disappeared and no one's heard from them.
Ms. Becker, do you know where Mr. Brackman lived?
No, I don't know how or why I would know that.
So did you go to Mr. Brackman's home on March 6th?
No, of course not. I had no reason to, and I don't even know where he lived.
And did you murder Mr. Brackman?
Absolutely not. I may not have liked Mr. Brackman very much as a coach, but that certainly doesn't mean I would ever do anything to harm him, let alone kill him. I feel terrible about what I did to his car, and I wish I had the opportunity to make things right with him. I certainly did not kill Mr. Brackman.
No further questions at this time, Your Honor.
Thank you. We'll pause a minute before we have cross-examination of the defendant. And Ms. Hunt, you may cross-examine Ms. Becker.
Thank you, Your Honor. Hello, Ms. Becker. I'm Eleanor Hunt, and I am an attorney with the prosecution. You went into practice that Tuesday night after regionals, expecting a pat on the back from Mr. Brackman for your role in the team's success, right?
To some extent, because I had done well at regionals, and it's natural to expect some kind of recognition.
That's not what happened, though, is it?
No, unfortunately. I mean, it honestly wasn't that surprising. Just typical for Mr. Brackman that he wasn't all too happy about it.
Mr. Brackman was upset with you.
Yeah.
Objection, Your Honor. Question calls for speculation.
Ms. Hunt, so the objection, Ms. Hayden, is the question was whether or not Mr. Hunt was upset. And you're saying that's speculation. Ms. Hunt, what's your position?
Your Honor, this witness has testified to this in her affidavit and in her direct exam that Mr. Brackman was upset with her in this instant. And if I need to read from the witness statement, I'm more than happy to.
whether the witness statement says it or not doesn't have anything to do with speculation, but the earlier question, she did testify to being upset, so it is now on the table. You may ask the question. The objection is overruled, so you may re-ask if you wish.
Thank you, Your Honor. Mr. Brackman said you were undeserving of the Best Attorney Award, right?
No, he did. He said all kinds of things, honestly, which was typical for him. He said, I just relied on my looks. I was just lucky. He had a lot of things to say.
And you got upset.
Yes, like I said, of course I was a little bit upset. It's not easy to be constantly insulted and berated by someone who's supposed to be your coach and your mentor. Yeah, but it was just pretty typical.
You were outraged.
Yes, like you like to use that word, I was at the time. And I was very upset, but yeah, of course.
And as he was berating you in front of the whole team, you stormed out of the room. Right?
Yes, I did leave the room. Like I said, it's hard to just be constantly insulted. So at that point, yes, that is what happened.
Yes. With a marker in your hand.
What I believe to be an expo marker, yes, is what I was holding. I didn't find out till much later that it was permanent, unfortunately.
And you saw his Porsche in the parking lot.
Objection, Your Honor. Was that a question?
It's a rhetorical question. I allow that during cross-examination. Every question does not have to have a question mark at the end of it. Let's proceed.
Thank you, Your Honor. You saw his Porsche in the parking lot, right?
Yes, I saw his Porsche that he was always talking about. The license plate said litigator with an 8. He really loved that Porsche.
And you scribbled worst attorney award across the hood, didn't you?
Fortunately, I did. It's one of my biggest regrets. No, actually, it definitely is my biggest regret. And I never would have done it if I had known the marker was permanent. I guess it was such a mistake, and I wish I could take it back.
And you claimed today that you thought it was a dry erase marker, right?
Of course, yeah. Like I said, I never would have done it had I known it was a marker. I honestly believed it to be an expo marker or a dry erase marker.
But the fact of the matter is that it wasn't.
No, we've covered that, but I didn't find out until much later.
Yes. You were out of control at that moment. Would you agree?
I suppose in some ways you could say that, but at the same time, I had no intention for permanent harm. I didn't really mean any harm. It was meant to just be something in the moment with an expo marker, a temporary thing to, tell Mr. Brackman what I thought. But
yes. And when Mr. Brackman saw what you had done to his car, he kicked you off the team, didn't he?
He did, yes. When he came out to the parking lot, he was rather upset, yes.
Ms. Becker, you claim that you never texted Alex Cifuentes, isn't that right?
I not just claim, it's the truth. I have never talked to Alex Cifuentes.
And you just said on direct that her testimony surrounding Exhibit 14 and the text messages was incorrect, right?
Well, not just her testimony, her whole statement. I was been told before that she's claiming I sent all these texts, and I have never sent her any texts.
Your Honor, permission for co-counsel to screen share Exhibit 14?
Yes, 14 has not yet been admitted, correct?
I believe 14.
14's in. Sorry, I didn't have it marked. My mistake. 14's in. It may be shown to the jury.
Thank you. Thank you, Your Honor.
Oh, there it is, way up at the top. I'm sorry, I found it.
Sorry. Ms. Becker, according to these messages that have been accepted by the court, they say you were planning to break into Mr. Brackman's house, don't they? I'm sorry, just for purposes of accuracy, they have not been accepted by the court. They've been admitted into evidence. Whether they are accepted is a matter for the jury. You may proceed. Okay, thank you, Your Honor. According to these messages, these say you were planning to break into Mr. Brackman's house, don't they?
According to the completely false and most likely forged messages, yes, these are absolutely not texts that I sent to Alex.
These texts, though, indicate that you told Alex Cifuentes that you were planning to trash Mr. Brackman's house, don't they?
No, I wouldn't say they indicate anything, as they're completely false and not texts that I ever sent.
Well, we can look at the words if you would like.
Sure.
They do, in fact, indicate that there was an intent to break into his house. You agree?
I would not say that because I never sent these texts, so they indicate absolutely nothing about my intentions. I never sent any text to Alex.
Ms. Becker, I'd like to go back to the night that you vandalized Mr. Brackman's car. Ousted from the A team, as you said, you went home and told your mom what had happened, right?
Yes, and fortunately, she gave me some really great advice on how to handle the situation.
Right. She gave you that advice after you conveniently forgot to tell her about what you had done to his car, right?
I wouldn't say forgot. I guess I was just so embarrassed and ashamed, so I left it out. It's not really the kind of thing you want to admit to your mom.
Yes. You excluded that crucial detail from the truth.
At that point, yes, but as I said, I later realized that the best thing to do was apologize and be upfront with Mr. Brackman.
But what you did tell your mother was that you would get back at Mr. Brackman if it was the last thing you did. Isn't that right?
Well, as you said, I was outraged at the time and I used those words, but I very quickly realized that that was an immature response that wasn't correct. My mom helped me realize the best thing to do was apologize, and I quickly regretted that and had not that reaction, no.
Yes, you were outraged when you said that.
As you said before, yes, of course I was. I was upset at the time, but it quickly disappeared and just turned into regret.
And this is what you told your mom, that you would get back at Mr. Brackman.
Objection, Your Honor. Asked and answered.
The question is slightly different about getting back. I'll allow it. Overruled. You may re-ask the question, Ms. Ms. Hunt, sorry.
Thank you, Your Honor. Ms. Becker, you told your mom you would get back at Mr. Brackman, right?
Once again, I did use those words, but I quickly realized that they were flawed and not the way to approach the situation in the slightest.
And in the text messages that we have just looked at, we can see that there was a plan to break into Mr. Brackman's house.
No, there was no plan on my part to ever break into Mr. Brackman's house. As I said, those text messages are not messages that I ever send.
Thank you. No further questions.
Well, wait a minute for redirect, or a moment. And Ms. Hayden, you may redirect the witness.
Thank you, Your Honor. Ms. Becker, what did you do to try and make up for writing on Mr. Brackman's car?
Well, I did all kinds of things. I just felt awful about it. I went to talk to him in person. I texted him. I offered to scrub the car. I even offered to get a new job to pay for repainting. I would have done anything. I just felt so bad about it.
And how did you feel about Mr. Brackman right before the time of his death?
I guess I just felt regret, and I just felt sorry about the whole situation. The way things ended was not how I wanted. I wanted the opportunity to smooth things over with Mr. Brackman and apologize and just get things right between us.
Thank you, Your Honor. No further questions.
And before we have recross, if any, we'll wait just a moment. And Ms. Hunt, you may recross the defendant.
I have no recross of this witness, Your Honor.
Thank you. Ms. Becker, you may return to counsel table. You're excused from the witness stand. And we'll wait just a moment for the third witness for the defense. And Ms. Fakes, if you would call your next witness, please, for the defendant.
The defense calls Taylor Perkins to the stand.
And we have Ms. Perkins on the stand. I will ask Ms. Perkins for you to introduce yourself with both your character name and your student name, please, for the court.
Of course. My student name is Alexander May, and today I am Taylor Perkins.
And Ms. Perkins, if you please raise your right hand. Do you solemnly swear or affirm under penalty of law that the testimony you're about to provide today in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And Ms. Fakes, you may proceed.
Thank you, Your Honor. Good afternoon, Ms. Perkins. Could you please introduce yourself to the jury?
Hi, everyone. I'm Taylor Perkins, Perkins, and I am a freshman at CU Boulder. Go Buffs!
Ms. Perkins, could you please describe your relationship with Mr. Becker? Or sorry, Miss Becker.
Yes. So Avery and I were like BFFs all throughout high school. I mean, like we were such good friends. She was able to get me to join mock trial. No offense, I wouldn't have exactly joined mock trial if it wasn't for her, but not to toot my own horn, I think I made a great attorney. But when Avery was demoted off the team, I stepped down. I really wouldn't do it without her.
Why was Miss Becker demoted?
Oh, ridiculous. So it was about like a month before regionals last year, and Avery came to practice a little unprepared. She hadn't really rehearsed, but you know, in classic Avery fashion, she pulled it off. Like, go off, girl. She did it flawless. She killed it, but Mr. Brackman didn't enjoy it, I guess, and he demoted her to B team.
All right, Ms. Perkins, let's try to focus on the question and give an answer to the question. Okay, you're wandering a bit. Ms. Fakes, you may proceed.
Thank you, Your Honor. Ms. Becker, do you think, or sorry, excuse me, Ms. Perkins, do you think Ms. Becker deserved to be demoted?
Absolutely not. I mean, Avery was like 100% A-team material. She worked so hard for mock trial. So that's why I stepped down about a week before the regional tournament, because once I stepped down, Mr. Brackman wouldn't have had a choice but to put Avery back on the team. And I guess it paid off because Avery won best closing argument and best attorney at the regional tournament. She so deserved it, but Mr. Brackman didn't seem to think so.
What do you mean by Mr. Brackman didn't think she deserved these awards?
Well, at a practice after regionals, Coach Brackman gave Avery a bit of a hard time about her performance, saying she didn't deserve the award, but she did get the awards.
Objection. Under Rule 602, this witness has a lack of personal knowledge of this event, and the defense has not established proper foundation that the defense was present when this happened.
My understanding of the answer was that this happened at a practice. If you could establish, Ms. Fakes, whether Ms. Perkins was at that practice to observe what happened from her personal knowledge.
Ms. Perkins, were you at this practice?
I was not, but Avery told me about this.
Sorry, go ahead.
I'm sorry, and Avery is defendant Becker, is that correct?
Yes.
Yes, Your Honor.
And Ms. Kim, do you still have the same objection?
No, Your Honor.
All right, the objection to hearsay is withdrawn. Ms. Fakes, you may proceed.
Ms. Perkins, how did Ms. Becker react to Mr. Brackman's words?
I mean, Avery seemed to get upset, and like rightfully so, mock trial was her life. And so Avery did proceed to write Worst Attorney Award on the hood of Mr. Brackman's car. But as she expressed to me multiple times, she seemed to feel horrible about it. She thought it was dry erase marker, but it turned out it was actually Sharpie. Sorry.
Did Ms. Becker try to fix her mistake?
She seemed to do everything she could to talk to Mr. Brackman. But he didn't really seem to want to hear it, and he kicked her off the team, unfortunately.
Objection. Under Rule 602, this witness still has a lack of personal knowledge about this. She did not say that Avery told her that Mr. Brackman said this.
Right, Ms. Fakes, we need a foundation from Ms. Perkins as to how she knows this, has personal knowledge of it. If not, I will exclude it. If she does have personal knowledge, I'll admit it.
Ms. Perkins, how do you know this?
Avery and I are like best friends. We had this conversation.
Let's proceed.
Thank you, Your Honor. And from your observations, how did Ms. Becker react to being kicked off the team?
Well, I mean, she really seemed to be a little freaked out about it. She loved mock trial and it was our senior year, so she wanted to be on the team. I think she texted people trying to get back on the team. People said they might talk to Mr. Brackman about it, I think. And I think she may have texted Alex Fuentes, but I'm not 100% sure.
Could you please, from your observations, describe Alex and Avery's relationship?
I mean, like, they seemed to be nice to each other. They weren't like BFFs or anything. They both cared about mock trial and both wanted to succeed in mock trial. Avery was one of the best on the team, though, and Avery always got the roles that Alex seemed to wanted. So Alex was always overshadowed by Avery.
Were Alex and Avery friends?
I mean, I spent a whole lot of time with them at mock trial, and they did not seem to be friends at all.
Ms. Perkins, could you tell me about the night before Mr. Brackman's murder, March 5th?
Yeah, Avery and I actually hung out that night.
What did you do?
So Avery swung by my house after school. We hung out, played some games on our phones, and then we got hungry, so we headed over to the Fry Shack, which was not a good idea.
Why not?
Most of the mock trial team was there for a post-practice snack, and when Avery saw them, she seemed to be upset and stormed off to the bathroom.
Was anyone with you while she was in the bathroom?
Yes, actually, Alex Cifuentes was.
And where was her phone while Avery was in the bathroom?
She left it on the table when she went to the bathroom. However, I'm not entirely sure if she picked it back up again when we left.
What happened the next morning, the day of Mr. Brackman's death?
So Avery and I have first period off together, so we would usually drive to school together. She hadn't actually answered any of my texts from the night before, so when I mentioned it to her, we both realized oh my gosh, her phone is missing. So we decided to spend the day looking for her phone. We retraced all of our steps.
Where did you look?
Well, we went to the mall, checking every store we'd gone into, and then we went to the Fry Shack. And then later in the day, we went back to the Fry Shack again to check with the afternoon shift. But while we were there, we saw the mock trial team again, which we always seem to do, and apparently Coach Brackman hadn't showed up to practice.
Did you try to call or text Avery's phone?
Yes, we actually called Avery's phone several times because I have an Android. I didn't think to Find My iPhone at the time or anything like that.
Did the police ever try to use your phone to check your call logs for that day?
They never asked to use my phone, no.
Did the police ever try to use your phone to check your location for that day?
No, they did not.
And was Miss Brackman's phone ever found?
I do not believe it was ever found.
Moving on, Miss Perkins, who is Blair Rollins?
So Blair was a kid who used to go to our high school. I don't really know a whole lot about that much about Blair. However, Mr. Brackman was once a lawyer for Blair's dad. Mr. Brackman lost a case that then sent Blair's dad to jail. And I think
under Rule 401 and 402 relevance and under 801 hearsay.
Both objections, Ms. Fay, to both hearsay and what's the other objection, Ms. Kim? I'm sorry.
401 and 402 relevance.
On relevance. Go ahead.
Your Honor, to relevance, this is very relevant as my witness has stated. Blair Rollins' father was sent to jail under Mackenzie Brackman's lawyering, which is very relevant to this case as Mackenzie Brackman was the man who was murdered. Under hearsay, I don't see, how is this hearsay?
Well, I would ask that the defense establish proper foundation as to how Ms. Perkins knows this. And if it is heard from someone else, I will object on the grounds of hearsay.
All right. Let's back up a little bit. As to relevance, I do believe that the issue regarding Blair is relevant. It may be, it's up for the jury to determine whether or not the suspicion of Blair is credible or not credible, and to what degree. If so, the police are alleged not to investigate. That's up to the jury. So relevance is established. It's up to the jury to decide the extent of it. As to hearsay, this issue is not being offered for the truth of whether or not the decedent was Blair's father's attorney, whether he lost the case or any other issue. The truth of that is not the issue. It is merely the fact of it and the effect on the listener, on how that may have affected the defendant, how it may have affected any other person, Blair, for instance. Effect on the witness, it is not hearsay. Let's continue. Objection is overruled. Ms. Fay, you may proceed.
Thank you, Your Honor. Ms. Perkins, what was the relationship between, would you like me to repeat my question?
Yes, that would be great.
Who is Blair Rollins?
Blair was a kid who used to go to our high school. I really didn't know much about Blair. We weren't like super close, but I did know that Mr. Brackman was a lawyer in a case that he lost, and that case ultimately sent Blair's dad to jail.
And was Blair at the school was Blair at school the day Mr. Brackman was murdered?
No.
Were you with Avery all day?
Yes, I was. We spent all day looking for her phone.
And did Avery murder Mr. Brackman?
No, I was with Avery all day looking for her phone at the mall.
Thank you. Your Honor, no further questions at this time.
We'll pause a moment before cross-examination by Ms. Kim. And Ms. Kim, it is your witness, cross-exam.
Thank you, Your Honor. Ms. Perkins, you are best friends with Avery Becker, correct?
Yeah, we were like best friends all throughout high school.
Right. And on the day that Mr. Brackman was killed, you ditched school for Avery, correct?
Well, like all of our classes were kind of dry. We had already taken the test. So we decided that school wasn't really the most important. And we really did want to find Avery's phone. I mean, those things are expensive. You don't want to replace it.
Right. So you skipped the entire day of school to look for Avery's phone, correct?
Yeah, I wanted to help her find it.
You say Avery's phone was like her third kidney, never out of reach, correct?
Yeah, I mean, we're all teenagers. We love our devices.
Mm-hmm. But you and Avery didn't notice that her phone was missing until the day after she lost it, correct?
Well, I mean, I'm not sure about what Avery noticed, but I brought it up to her. I wasn't with Avery that night, so not entirely sure what Avery noticed. However, I did bring it up, and Avery did seem surprised to the fact that she did not have her phone.
Right. So if Avery was so attached to her phone, like you say, don't you think it's a little bit unusual that it took you guys that long to notice it was missing?
I mean, I can't really testify as to how Avery felt about it being missing and unusual. But as I said, I did think it was unusual that Avery wasn't responding to my text, which is why I brought it up to her when we got in the car.
Yes. And this supposed phone search is what makes up the entirety of Avery's alibi, correct?
Yes, we spent the entire day retracing our steps looking for her phone.
Yes, looking for her phone that happened to be missing, even though it never leaves her side, correct?
I mean, I'm not sure about her phone never leaving her side. I mean, it could have left her side that night. I mean, she seemed to have left it at the mall. That's why we spent all day looking for it.
Ms. Perkins, you just said that her phone was never out of reach, like her third kidney. That implies never leaving her side also, correct?
I mean, sure, but I cannot testify to where Avery's phone was that night as I was not there.
Okay, thank you, Ms. Perkins. You said in your direct, you wouldn't have done mock trial if Avery hadn't done it, correct?
Yeah, I wasn't really into that stuff. I really just did it to spend time with Avery. It was fun.
And from what you've observed of Avery's participation in mock trial, you know that Avery doesn't really put in any effort, correct?
She's really a natural at it. She didn't really need to put in the work.
So yes?
Yeah, she didn't have the need to put in the work.
And your coach, Mr. Brackman, was very frustrated by this, wasn't he?
He seemed to be, but I mean, she always pulled it off.
Objection, speculation.
I'm sorry, the objection is?
Calls for speculation.
Speculation as to what? I couldn't hear the answer because of the objection. I apologize.
Sorry, Your Honor. Ms. Kim asked if Mr. Brackman was frustrated. This calls for speculation.
May I respond?
And Ms. Kim, yes.
I believe that someone can tell if someone is frustrated based off of the way they stand, the way that their face looks, the way that they're acting. I don't think that it's calls for speculation of his inner thoughts and feelings. I can re-ask the question in a different way if you would like me to.
If you would re-ask the question about her, if she has a perception that she is testifying to, that would be fine. Go right ahead.
Thank you, Your Honor.
Thank you, Your Honor. In your perception, Mr. Brackman seemed to be frustrated by this behavior of Avery's, didn't he?
Yeah, he seemed to be frustrated by it, but I'm not really sure. I mean, she always pulled it off in the end.
So he kicked Avery off the A team because of it, didn't he?
Yeah, he did seem frustrated about it, but as I said, I really don't know why. Avery always pulled it off. She always did great.
And after Avery was kicked off the team, you quit in support of her, didn't you?
Yeah, I mean, mock trial wasn't that important to me, and Avery was 100% A-team material. She deserved to be on A-team, so I stepped down. It wasn't that big of a deal. I didn't love it that much.
But Mr. Brackman did let Avery back on the team eventually, didn't he?
Yeah, I mean, the team wouldn't have been able to go to state if I stepped down or regionals if I stepped down and Avery also wasn't on the team.
Even though Avery tended to act in a rash manner?
I mean, everyone acts irrationally every now and then, but I wouldn't say overall Avery acts in a rash manner.
Do you agree with me if I say that in your testimony that you signed prior to trial today, you did say that Avery tended to act in a rash manner, correct?
Sure, she had the right to be upset about Mr. Brackman's comments and his constant belittling.
So Avery has a temper, wouldn't you say so?
I think we all kind of have a temper inside of us.
And one time, Avery was so angry that she vandalized his car.
Yeah, Avery expressed to me how horrible she felt. She thought it was dry erase marker turned out to be Sharpie. She constantly tried to apologize to Mr. Brackman, but he didn't want to hear it.
So upset, so angry that she willingly marched out of practice with a permanent marker to deface his car.
I can't say if she willingly knew that it was the permanent marker. Based on my conversations with Avery, she told me that it was a dry erase marker.
I'd like now to talk to you about someone named Blair Rollins. You were not close with Blair, were you?
No, he's just a kid at our school.
And you were also never close friends with Alex Fuentes, correct?
Not really. We were on the same team. I guess we got along, but we weren't like friends.
Yet you say that Blair and Alex were good friends, right?
They seem to be, yeah.
But you don't know anything about their relationship, correct?
I mean, based on my observations, they seem to be good friends. I'm not inside their heads, so I couldn't know 100%. But based on what I observed, they did seem to be good friends.
You have no knowledge of them ever hanging out?
No, as I said, I'm not really good friends with either of them, but based on what I observed, they did seem to be good friends.
But you have no knowledge if you've ever observed them interacting with each other?
No, I never saw them interacting with each other. Also, I do not believe that is in my statement. I can answer if you'd like.
I'm simply asking if the fact that you do not know, because it is not in your statement, if Alex and Blair were ever hanging out is true, correct?
That is not in my statement. I can answer if you'd like. However, I do not bring that up in my statement.
Okay, thank you. Ms. Perkins, you never liked or respected Mr. Brackman, correct?
I mean, yeah, I always saw him belittle Avery's efforts, and it wasn't really fair to Avery. I mean, he was supposed to be a coach, a mentor.
Right, you call him a mediocre coach and say those who can do, those who can't coach, right?
Yeah, I think that was a pretty mutual thought about across everyone on the team.
Thank you, Taylor. No further questions, Your Honor.
We'll pause a moment before redirect. And Ms. Fakes, you may redirect your witness.
Thank you, Your Honor. Ms. Perkins, how would you observe the relationship between Blair and Alex to be?
Objection. Under Rule 602, this witness has established that this witness has no personal knowledge of that relationship, as she was not friends with either of them or has no knowledge of them ever being together outside of practice.
Except that she did testify that she observed during practice. I will let her testify to that extent. So if the question is restructured in that manner, it is admissible. Let's move on.
Right, Your Honor. Ms. Perkins, to the extent of your time with Blair Rollins and Alex Fuentes on the mock trial team, what did you observe their relationship to be like?
I mean, they seemed to be friends. We spent a lot of time at mock trial practice, and throughout the time that I did spend with them, they did seem to be friends.
Thank you. No further questions, Your Honor.
And I believe we have a rough time check for recross of about 10 seconds. Ms. Kim, if you wish to use that, you may.
I have no recross, Your Honor. Thank you.
Thank you. Ms. Perkins, you are excused. Thank you very much. And do we have any additional witnesses for the defense? Lead counsel?
No, Your Honor.
And does the defense rest?
Yes, Your Honor.
All right, before we have
closing arguments, we will pause for a moment while the scorekeepers can catch up. And I believe Ms. Amon is closing for the prosecution. Is that correct?
Yes, Your Honor.
And who will be closing for the defense?
I will be Miss Hayden.
Thank you very much. And it'll just be a moment before we proceed with Ms. Amon. And Ms. Amon, closing argument for the prosecution. You may
Yes,
proceed.
Your Honor. And I would just like to clarify or double check that we will have remaining time reserved for rebuttal.
Yes. And do you wish any time notifications prior to your completion of your primary argument?
Yes, I mean, the regular time they've been doing in the past says 1 minute, like 4
1 minute
minutes, 3
increments?
minute. Yeah.
1 minute increments. Thank you very much. Timekeepers will do that for both teams, and you may proceed.
Thank you. Ousted, outraged, and out of control. Members of the jury, Miss Becker was used to getting away with everything until everything got away from her. On March 6, 2020, Avery's emotions got the best of her for the third and final time. The first, as she told us ourselves, she was ousted from the A team. The next, as she said, she was outraged by Mr. Brackman's constructive criticism and irrationally turned to vandalism. And the third time, everything got out of control. Avery was kicked off the team and felt like she'd been stabbed in the back. Her response, to do the same to Mr. Brackman. We must prove beyond a reasonable doubt, meaning not just any doubt, and certainly not a doubt which is vague, speculative, or imaginary, that Avery committed second-degree burglary and felony murder. We don't need to prove Avery intended to kill Mr. Brackman, just that her planned burglary got out of control. Today, we have met this burden. As I walk us through the elements of these crimes, you will see the evidence lies in the answer to 4 questions. First, did Avery enter Mr. Brackman's home? Yes. Detective Markowitz, an expert in cell tower data, told us Avery's phone was located near Mr. Brackman's home during the date and time of the crime, and provided ring footage of an intruder of the same size and build as Avery entering the home. Now, the defense attempts to discredit this through Ben Owen's speculative review of the information, not even a true investigation, and goes even further to provide a less credible alibi, saying Avery and Taylor spent the whole day looking for a lost phone. If that doesn't raise enough doubt, let's take a look at the source of this unlikely story. Taylor, the same Taylor who quit the mock trial team for Avery, the same Taylor who is Avery's best friend. Second, was Avery invited to Mr. Brackman's home? No. When was the last time you greeted a welcome guest with a kitchen knife drawn in self-defense? Third, did Avery plan to commit a crime? Yes. Not only did she tell her mom that she was going to get back at Mr. Brackman if it was the last thing she did, but she texted Alex saying, I'm going to wait until he's at work and then break in and trash his home. Ask yourselves, does that sound like a plan? And finally, was Mr. Brackman killed in the course of these events? Yes. Expert witness Kyle Kuzak walked us through all the links in the evidentiary chain, showing how Avery broke into Mr. Brackman's home. The two struggled through the kitchen, knocking over a plate, and in the midst of the chaos, Avery grabbed his knife and stabbed him back, letting him stay to bleed to death. Now, the defense again falls short in their efforts to disprove this through, as she called herself, a check on the power of the police, Professor Van Owen, who provided no evidence to her theory because all she wanted to do was make the police look bad. You heard it. Avery had a special talent. She could pull it all off. She had won awards as a witness in mock trial from the same stand in which she spoke to you today. But this is no longer mock trial. Actions have consequences. We've proven beyond a reasonable doubt that Avery committed second-degree burglary and felony murder. Find her guilty of such. Thank you.
Thank you. And we will wait a moment before closing for the defendant. And remember, the timekeeper will calculate time for rebuttal for the prosecution. And Ms. Hayden, closing argument for the defendant.
Yes, Your Honor. Your Honor, members of the jury opposing counsel. In this case, there's no phone, no files, and there can be no felony. Might I remind you that the prosecution holds the entirety of burden of proof in this case. That means that they need to prove each element beyond a reasonable doubt. Not only have they failed to do this, but they have failed to prove any element. The prosecution has brought forth a case saturated with incompetence, both in the evidence that they did collect and in the mounting evidence that they failed to consider. No phone, or should I say phones. Both Detective Markowitz and Mrs. Kuzak would lead you to believe that they are sure of the whereabouts of my client on March 6th. They want you to think that the cell tower data that they found tells us everything that we need to know. This simply isn't the truth. Cell towers are not tracking devices. Phones don't always connect to the nearest one. Besides, regardless of the path that Miss Becker's phone took on that day, it was not in her possession. On the other hand, there were two phones that Detective Markowitz did know the location of. Neither Taylor Perkins' phone nor Alex Cifuentes' phone were investigated in this case in the slightest. Mrs. Kuzak chose to hinge her entire case on screenshots sent to her by a teenager that could have been fabricated in Photoshop in under a minute. Why? Because she was simply too lazy to investigate further. This laziness is also apparent in the fact that Detective Markowitz did not choose to investigate Taylor Perkins' phone, which could have either confirmed or denied Avery's alibi on that day. Next, no files. And yet another example of the police department's gross incompetence, the experts in this case lost evidence. Ladies and gentlemen of the jury, how can we say that this case is open and shut when experts cannot even keep track of evidence? Finally, the felony. Today, Avery Becker is being falsely accused of second-degree burglary and murder in the first degree. The prosecution's story simply leaves too much room for doubt. We don't know if Bracken was alerted to the intruder. We don't know if the knife came from inside the home. We don't know if the assailant stabbed Brackman in the front or the back. And we don't know Avery's exact location on March 6th. Simply put, we don't know who murdered Mackenzie Brackman. Here's what we do know. We know the prosecution failed to look into any other suspects, including Blair Rollins, whose father, Mr. Brackman, sent to jail. Rollins was not at school on March 6th and seems to have disappeared ever since then. This, of course, did not stop Detective Markowitz from including Blair Rollins' home on Exhibit 15, a map of the cell tower records. We also know that the prosecution's only character witness admitted to being jealous of Avery Becker. Mr. Fuentes was the one who pointed Detective Markowitz to Avery using forged screenshots. Members of the jury, might I remind you that Alex Cifuentes was the last to see Avery's phone on March 5th? We know that the prosecution claims that Avery Becker was outraged, and out of control. They want you to believe that Becker carries a fiery vendetta against Mr. Brackman. Today, Becker simply testified to how she was sorry for her actions. Does a woman who offered to get a job to pay for Mr. Brackman's paint job sound out of control to you? We know that the prosecution took the easy way out. They made assumptions across the board and failed as investigators. They built their case not based on evidence, but on the first suspect that they could find. Finally, we know that there's more than a reasonable doubt in this case. There's a sizable one. The evidence presented to you by the prosecution has absolutely failed in every way. Today, my co-counsel and I have shown that there was no phone, no files, and there can be no felony. Since the prosecution absolutely failed to prove beyond a reasonable doubt any element of this crime, which are first-degree murder and second-degree burglary, you must find my client not guilty. Thank you.
Thank you. And before we have the rebuttal closing for the prosecution, could we have a time check on the prosecution's time?
I have 42 seconds left.
And we'll wait just a moment. And Ms. Amon, rebuttal closing for the prosecution, please.
Yes, Your Honor. The defense claims there's no phone, no files, no felony. Yet they have provided no investigation, no evidence, and no reasonable doubt. Why? Because they can't. Because they know when Avery was ousted, she became outraged and everything got out of control as she stabbed her coach to death in his home. Thank you.
Thank you very much. That concludes the trial of the defendant in this case. Congratulations, all of you. The scoring panelists are now going to complete their scoring and submit their scoring sheets. During that time, I am prohibited from making any individual comments about your conduct. I know they would not be influenced by my opinion, but that's why I can't say anything. They will appear back on the screen when they have submitted their sheets. However, I wrote these words down about halfway through. My. You folks are superb. All of you ladies, including Mr. Filerman. I have not been so impressed in years. You are absolutely astounding. The confidence that I saw, the eye contact, you are both teams, all witnesses, all attorneys. It was remarkable. There are no weak links here. You're just remarkable. As a, let's see if I don't know if I have everybody back yet, Mr. Prey, Mr. Henderson, and if I got Maggie, I have all of the scoring panelists. I'll reserve my comments other than that. It was just truly remarkable. Mr. Henderson, if you'd like to go first.
Certainly, Your Honor. And let me echo Judge Wheeler's words.
And echo Magistrate Ryan for that matter.
Everyone's words or Judge Wheeler's words. Wow. Both teams, phenomenal. And I will tell you on my score sheet, it's razor thin, the closest that it could possibly be. So just phenomenal work. And let me say, both openings and both closings without use of notes and your body language, which is tough in Zoom, but could really tell that both teams had really worked hard at trying to have body language and hand motions and use of eyes to kind of look up when you're trying to send a message was just outstanding.
And I'm going to interrupt Tom for just a moment. Our Bar Association person, can we confirm that everyone has submitted their scoring sheets?
We have all the scoring sheets. I'm gonna let you guys go ahead and still give your feedback. Once you guys are done giving your feedback, just so you know, your coaches will get who is gonna be moving on and who is not. It's devastating for me not to have the ceremony because that's my favorite part of this event, but that's how we have to do this year. So just so you know, as soon as everybody's done with their comments, I'll just end the live feed, okay? Thank you guys.
Thank you.
And let me say, professionalism on both sides, outstanding. There was no even veiled suggestions that your opposition had done something inappropriate. So just outstanding in that regard. Just one funny thing that I heard, and I will tell you, it was a good thing my screen was blacked out because a number of the witnesses, your remarks had me laughing out loud. But Lily, when she said scuff marks of doubt, that just kind of struck me. Let's see, Ms. Hunt, in your direct, excellent use of questions of laying a foundation. As Judge Wheeler can tell you, many lawyers struggle with that, and you really did a phenomenal job. Ms. Kim, your body movements during your opening were phenomenal. You know your rules backwards and forwards, and really loved your step-by-step on the using the talking about the use of the or grabbing the marker. Ms. Amon, you were really efficient in the way that you went through the investigation. And let me tell you that your recross, which was short, succinct, and powerful, that was awesome. Your recross, I think it was one or two questions. Ms. Murphy, great use, or good cross using the multi-step process where you kind of played it back with the different steps. Ms. Fakes, again, the opening was really excellent. Great knowledge of the rules on objections or with objections, and your leading questions and your cross of Cifuentes were excellent. Ms. Hayden, really skillful use of segues between different topics and signposting. And the cell phone cross I thought was just superb. So I think I've touched on all 6 of the lawyers. So let me just say one more time, excellent, excellent work. And it was truly a privilege to get to listen to both teams this afternoon. Thanks.
And Mr. Prey?
Yeah, happy to say I really liked the way both closings turned around those alliterative references, the ousted, outraged, and out of control, and the no phone, no files, no felony. They each turned them around on each other.
I'd like to make a comment about Mr. Prey. This, for you participants, Mr. Prey, and I didn't know this, not being an attorney, this is really important what he says, because he is a real juror here. You know, he's not a lawyer like the rest of us listening to this stuff.
Well,
what matters to him really matters. So go right ahead.
Yeah, I guess I am kind of a real juror, but I've gotten, after 6 years of this, I've gotten over the idea. The very first year I did this, I wanted someone to be guilty or innocent. I'm past that now, well past it. I'm looking at your performances. These were really, really wonderful. Everybody did a great job. It's hard to pick somebody out. The openings and the closings were very good. All of the attorneys and witnesses were excellent. I have no, there's no complaints in here about anybody having any lack of knowledge. Everybody knew their part. They knew their role. They knew the information they were supposed to have, and they did an excellent job. I would like to say one thing. Miss Murphy, Miss Humber, and Miss Amon, your round where you went around with each other, that was a wonderful sparring match, and I enjoyed that quite a bit. The other one was Miss Faye, Miss May, and Miss Kim. Last witness, last defense and prosecution. That was really, really good. I enjoyed it quite a bit. I've had, you know, this has been a really good round. I enjoyed it. Thank you.
And Magistrate Ryan.
I just want to give everybody a round of applause. Great job. This was definitely a very competitive round, So I want to congratulate you all. It's so nice to be done. I'm not going to go into specific comments that I have for each of you. If you desire them, you can stay after and ask me about them. I'm just going to give you some general commentary. Certainly, you all got the content in your lines of questioning. You know what was important, you highlighted what was important, and you didn't go into things that didn't need to be hit on based on whatever your theme was or where you were going with things. So great job with that. Really great job with the arguments. I'm going to start nitpicking because you guys are good. So when you're looking at the rules, those rules that you have, you've got to be clear. There are some arguments that you were making with the rules where you were missing parts of the rules. And so you guys are at that level now where there's a little bit of nitpicking going on because I know you guys are that good. So just be careful. For example, 804 has two parts to it. Just remember that. Let's see. I will tell you, I've been watching for a while. I've had the pleasure of watching folks testify via this format. I may be a little bit more skilled in the note watching than others might be. I did see some of you that were using your notes. I would be careful about that as you're getting into the higher levels. You want to be off of your notes during the full presentation when we're talking mock trial. You get scored based upon that. And so for purposes of the mock trial competition, if you're doing directs or crosses, try to get off those notes so that you're not reading from them as you're going along. It'll also help your inquiry look a little bit more skilled and a little bit more professional if you're just playing off the answers you're getting and just going to the next question based upon what you're receiving. Witness control is hard in this virtual environment. I get that. Let's see. One thing I would comment on for witnesses is be careful. If you go to the mock trial, the main Colorado high school mock trial page, there's some information about witnesses that was put up there by a great expert witness. And I would encourage you folks to read through that because some witnesses might have gotten a little bit unfair and maybe that was the character play here. But if you are way too overboard on your treatment one side over the other, your credibility might be hurt as a witness. And so I'd encourage you to try to be even-handed as a witness with your treatment of both sides. I also, I want to finally say you guys did such a great job. I saw high-level techniques being used here. I saw people doing double directs. I saw expansion. This was a very competitive round and you did a great job. So last time, great job. If anybody wants to ask me specifics, I can do that after.
Thank you. And I would say Magistrate Ryan is not just an excellent magistrate, but she's a real expert in this, in mock trial. Mock trial is a little different than actual trial work, and she knows what she's talking about. So asking for her opinion, you'd be well advised to do that. I have a couple of comments here, and because it's the last round period, you're not waiting for anything other than to give each other a virtual hug, which unfortunately, I always enjoyed that. The end of the trial, everybody congratulates everybody. It's really great. And the coaches come up and the family and the friends, and it's great. And I'm so sorry that you can't do that. I know how much this means to you and how you are missing out on that camaraderie. So the comments I have, we had a lot of you filled up your time completely. You know, you used all your time, you very judiciously parceled it out to the things you felt are important. One thing you might think of
we had several expert witnesses here who were passed on all or some or most of their qualifications. A couple of witnesses, passed entirely on their qualifications. And that's fine. You move on. The comment was, we'll deal with that on credibility. Consider that you can always double hit the jury with that credibility issue by simply exposing it in a short voir dire and saying, well, Your Honor, based on that, I will withdraw my objection and deal with that credibility issue. But then you've raised it. The jury's heard it right up front, and then they hear it again when you're doing the questioning. Just a thought. Also, be careful. And when I say this, I say it to two teams, one or both of which may very well proceed here from this competition. You were so good. I'm not a scorer, so I can say that. You are both certainly qualified to move on, in my opinion, both teams. Should you do that, be very careful when you, on either side of the case, when you talk about, well, especially on the defense side, if you talk about problems in the evidence with the prosecution, remember that it's not the prosecution that created the evidence, it's the police. You're criticizing the police, not the prosecution. And that was raised in another trial, and I find that an important comment, that it's the police you want the jury to be critical of, not the prosecution. Now, if something were to happen with a prosecution attorney or a defense attorney, that would be a professionalism issue, but we had none of that here. So just be aware of that. And the final thing I wanted to say is both sides of the case did this and drew no objection. And I will tell you that an objection to a suggestion that the defendant has anything to prove, whether it is merely a comment of proof by the defendant, that should be a rocket ship under your butt to get up on the other side and object that the defense has nothing to prove. It is always a great objection, and it's a meaningful objection to the jury, especially if it were in opening, or in this case, there was a comment like that, but in closing about that the defense did not prove something.
Judge Wheeler, I'm going to interrupt just a moment. There's a technical rule there, and I'm going to put it out. At least it was last. As it relates to openings and closings, you're not supposed to object during them, but you can at the end get up and say, under the mock trial rules, if I were allowed to object during openings and closings, I would have objected to this. So there's a method for doing it, just to clarify.
I wasn't aware of that. And that's why we have an expert here in mock trial. But even so, that would have been a good objection even after the fact, because, be aware of that if any of you decide to become attorneys or trial attorneys, because boy, it is a tremendous objection. It makes a huge impact on the jury when you indicate that somebody has stepped out of bounds like that. But thank you, Echo, for correcting me there. Otherwise, get back to your friends and your families. You just did a wonderful, wonderful job. Congratulations. I am very optimistic about both of your teams. I hope I'm correct about that. So thank you very much. If you'd like to stay on this line and talk to anybody, I'll be on it too, as will Magistrate Ryan and anyone else who wants to stay for individual questions you might have. So I will not close the meeting yet until I'm told to. So if any of you want to.
I'm going to go ahead and stop the live stream right now. So anybody that wants to drop off, they can, and then I'll leave you guys open for just a little bit longer, okay?
Thank you.
Thank you.
So coaches.